ಹೌದಾ ಮೇಡಮ್? ಹಾ
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತಲ್ಲ ಹಾಗೆ ಎರಡು ಎರಡಿದೆಯಾ
CW1 to CW7.
Now they are already examined before the court.
They have already been examined.
Who are they?
PW1 with CW1, my lordship. PW2 with CW2.
CW, we are not concerned now.
PW1, 2, 3, 4, 5, 6, 7, my lordship.
PWs 1 to 7.
Please, my lordship.
Are they eyewitnesses?
Please, my lordship. There are.
They have supported.
They have supported, my lordship.
Then recovery is there. Yes, you have to tell.
Please. Postmortem has been done, my lords.
No, whether there was any recovery. At the
Recovery
instance
is
of
there,
the-
my lordship.
Who speak about recovery?
That is Mahajar witness.
Apologies, my lords.
You should be thorough with the facts, sir.
So apologies.
Then why
my
you
lords.
moved the petition now?
My lords,
Earlier on merits it is held you are not entitled for bail.
please, my lords.
Then why? What is the reason? Simply because some witnesses are examined, petitioner will not be released on bail. You have to make out a ground.
My lords, the ground is, my lords, the case is that he is accused of murder. Now my specific contention is that there are no ingredients of murder because I have.
It is already held. On merits, your earlier petition was dismissed.
Please, my lords.
At that time, it is held. Your contention that there are no materials are rejected, and it is held there are prima facie materials. And the offense is punishable either with death or imprisonment for life, and therefore you are not entitled for bail.
Please, my lords.
Same argument you cannot address now.
My only contention was that material with
But
liberty
they
was
have
reserved.
supported the case of the prosecution. Still, it has.
PW 12 and 13 are the Mahajar witnesses on the recovery of the weapon, my lordship. As per the instinct of the accused, my lordship. They have also supported, my
They have
lordship.
supported the prosecution.
Not in. Let the few official witnesses are to be examined. Insist the court to take up the matter. First.
Liberty may be reserved, my lords.
Liberty for what? Seek for acquittal. That is what I am saying. When the all the material witnesses have supported, there is no other go. You have to address your argument for acquittal last time. That is the only way.
Please.
The earlier order, para 1 same, para 2 heard so and so, para 3. Learned counsel for the petitioner submits that the petitioner had filed criminal petition 12519 of 2022 before this court seeking a release of the petitioner on bail. However, the said petition came to be dismissed on merits with a order dated 18/1/2023. Now it is the contention of the learned counsel for the petitioner that since the liberty was reserved in favor of the petitioner to move the trial court after examination of the material witnesses, the petitioner had moved similar application before the trial court, but the same came to be dismissed. Hence, the petitioner is again before this court. Next, on perusal of the order dated 18/1/2023, this court, after considering the contentions taken by the petitioner as well as by the state, formed an opinion that there are prima facie materials against the petitioner for having committed the offense, which is punishable either with death or imprisonment for life. And that the petitioner is not entitled for bail. Liberty was reserved in favor of the petitioner to move the trial court for bail after examination of the material witnesses. Now it is stated that all the eyewitnesses are examined as PWs 1 to 7. The witnesses to the recovery Mahazar are examined as PW 12 and 13, under which recovery Mahazar, under which the weapon used in commission of the offense was recovered At the instance of the petitioner are examined as PW 12 and 13. It is not in dispute that all these material witnesses have supported the case of the prosecution. Therefore, the case of the prosecution has strengthened after examining the witnesses. Under such circumstances, I do not find any ground to enlarge the petitioner on bail. Accordingly, I answer paper point. Yes, dismissed.
Grateful.
Serial number 28, serial number 8, Sharath Jayam.
For the petitioner, kindly pass.
Pass over.
Serial number for hearing an eye, serial number 9, Jayam Umesh Murthy.
My lord, I appear for to the respondent, my lord. Petitioner, I have filed this application for recalling my lord, which is dismissed for default, my lord. Previous, it is true, my lord, we have received along with no objection from the previous council, my lord. But subsequently, because of ill health, my lord is not engaged with council immediately. So the matter had come up before this court and on 26/6/2025, my lord, dismissed for default, my lord. My lord, I have filed the application for recalling as well as the delay in application, my lord, delay in filing the application.
Yes, what is
I
it?
haven't received a copy of their application, my lord. My
Then-
name showed up today.
Without serving the copy, how can you?
Lord, I served, my lord, but anyhow, I will serve the one more copy.
Serve.
My lord, one preliminary objection I have, my lord, is that on 37/2024, my lord, the council, the previous council entered appearance and said that he has sent the papers back. It is In 2024, my lord.
Yes,
They have now come up after in June 2025, after the dismissal.
subject to cost.
My lord, I'll place my objections. Let me at least produce what they have filed, my lord. A short.
Counsel for respondent submits that he has not yet received the copy of the application. Counsel for the petitioners undertake to supply the copy of the IA 1 and 2 of 2026. For objections, if any. Yes. Short date, good.
2 weeks, my lord.
Next.
Serial number 10 for further arguments, Chandranath Ari K.
Delhi.
Serial number 10, Chandranath Ariga.
Pass over.
Serial for preliminary hearing B group matter, serial number 11, Srinandan K.
This writ petition I had filed seeking for the conditions to be removed insofar as the defreezing order was concerned. I believe, my lord, on the last date, your lordship had asked my colleague as to those are standard conditions, how can it be removed? If your lordship kindly sees the cost title, I have filed this as a company and I'm a resolution professional appointed by the Honorable NCLT.
No, you are aggrieved by which condition?
All the conditions.
So without any condition, it is to be.
I will, that is what I'm going to explain, my lord, because
You
today,
should have challenged that order, earlier order.
my lords,
Conditional order, you should have challenged.
that is what I have challenged. I have challenged the conditional order only,
Which court passed the order?
Sessions Court. I've come here before your lordship as the court commissioner appointed by the Honorable NCLT. I've not come as an individual or anybody else. If your lordship kindly sees the cost title for a moment.
1 minute. Yeah. Yes.
This is the company Green Farm Tech Private Limited, represented by resolution professional, one Mr. Jugraj Singh Bedi, appointed by the order dated so and so by the Honorable NCLT.
Yes.
Now, what has happened, my lord, is this. There are some debenture holders. The debenture holders file a case against the company, basically saying the company has done some fraudulent activity. They also go ahead and file a NCLT petition before the Honorable NCLT. Honorable NCLT admits that particular petition.
Yes.
The company's management is removed altogether. And I am appointed to take over this company and do the process of corporate insolvency resolution process under the aegis of the NCLT itself. Now, as per the NCLT order, I have to open a bank account to do the process. The process is this. What ends up happening previously when the old act was there, the official liquidator used to manage the company and then sell all the assets of the company. Now the new act, what it does is, it first tries to revive the entire process and try to revive the company. For that process, what they do is, they appoint me as a resolution professional, who's a court commissioner. I will take over the company and I will open a bank account called as the interim finance account. This interim finance account, the purpose of it is, I will collect the money from the creditors of the company, which is the complainant themselves, and use that to function the company and see whether I can sell the company for a better price. If I'm unable to do that, then the company will go into liquidation. Now this account has been opened by me after the NCLT order, and I've taken the money from the complainants themselves, and I have to do the work. Now they have frozen that bank account, which I have opened under the aegis of the NCLT. Because they are under the impression that this is the company's account, therefore I'm going to freeze it. It is the company's account, but opened after the NCLT order. Now, as a court commissioner, I can never satisfy such conditions.
Where is the NCLT order to open the account?
Please. 54 page number. The next page, your lordship will find 55. The case which is filed, the cause title. One Mayank Harshit Talati files the case against Green Farm Tech Private Limited, which is the main petitioner here. Then I would request your lordship to kindly go to page number 63. This is the operative portion. In the result,
Page number?
63. Paragraph number 11. In the result, by exercising powers conferred on the adjudicating authority under so and so, under the extant provisions, company petition bearing so and so, in respect of corporate debtor Green Farm Tech Private Limited with the following consequential direction. 1. We hereby appoint Mr. Jugrat Singh Bedi with registration number so and so as the interim resolution professional to conduct the corporate insolvency resolution process in respect of the corporate debtor, namely Greens Farm Tech Private Limited, and to carry out the function as mentioned under the Insolvency and Bankruptcy Code and the rules framed by the IBBI from time to time. The following moratorium is declared prohibiting all of the following, namely the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. B. Transferring, encumbering, alienating or disposing of by the corporate debtor any of his assets or any legal right or beneficial interest therein. C. Any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property, including any action under the SURFACE. D. Recovery of any property by an owner or lessor where such property is occupied by or in possession of the corporate debtor. E. Supply of essential goods or services to the corporate debtor as may be specified. F. And this is how the moratorium goes, giving conditions saying do not disturb the corporate debtor as long as this commissioner is there, because he now has to work under my order.
You are appointed as a what is that?
Resolution professional.
Resolution.
Interim resolution professional.
Is there any specific direction to open this account, interim account?
My lords, that is part of the process. By practice, it is opened. In fact, I filed an application before NCLT. NCLT said, anyway, you preferred before writ petition, please go for that. What ends up happening post that is, my lords, there has been several other judgments.
When the account was opened?
After this order was passed, my lord.
When this order?
This order is dated 22/2020.
Account was opened on?
That's the exact date. I have opened it 1 month afterwards. The exact date I may have to clarify.
You have to clarify, sir.
I will
because
provide that exact date.
you have specific contention that as per the NCLT
Yes.
order,
Yes.
You have opened it.
Yes.
Where is the order passed by the trial court?
Page number 32. The operative portion is 44. The application filed by the applicant, Green Farm Tech, represented by resolution professional so and so, is hereby allowed bank account bearing so and so of the applicant maintained by him at Karnataka Bank is ordered to be defreezed with the following condition. Applicant shall furnish the copy of the bank account statement as on the day on which the investigating officer has reported freezing bank account of applicant.
What is the difficulty in complying this?
My lords, the first one is not an issue.
Mere submission of bank statement.
The first one is not an issue. Now I request your lordship to see 2 and 3.
Then
The applicant has to execute the indemnity bond and surety bond for the amount standing as on date on which the investigating officer has reported. I am a commissioner, court commissioner. How can I give a surety with regard to it?
third one.
The applicant shall undertake to make good of the amount in the event of applicant being found liable to pay the said amount and abide by the order of this court. This also I cannot, because NCLT will take over this particular amount and they will distribute it to the very same complainants. In fact, the first condition, we have already been cooperating with the police and we have been giving them the documents.
As a resolution professional, your task is to revive the company.
Either revive the company. If I'm unable to do so, then I will tell the NCLT and give a report saying that please liquidate the company and dissolve the company altogether. And in the process, my job is also to find out whether the previous management of the company has done any fraudulent activity. I have found that they have done so. I have filed a fraudulent application before the Honorable NCLT. An order is already passed saying that they have done certain fraudulent activity. They have to pay a couple of crores to the complainant or else necessary arrest action will be taken against them. So that process is going on separately. Now, meanwhile, the previous management has come with a proposal to settle these complainants, and they have submitted that proposal before the Honorable NCLT.
Who is the applicant before NCLT?
One Mayank Harshit Talati, he is one of the complainants in this. It's a group of complainants, my lord, because debenture holders, almost about 200 debenture holders are there. Several of them filed this particular complaint. And all of them gather before the NCLT.
At whose instance the present complaint came to be registered in Ilva? At whose instance the criminal case came to be registered?
The very same debenture holders, 5 of them, I will just show the FIR copy.
Page number?
32, page number 32.
32 is the order.
32 is the order. I will have the FIR. It is there before the sessions court, my lord. I will have it produced once more.
No, that is the basic document you have produced.
The FIR copy, I'll place it on record. The order of defreezing, the freezing, your lordship will find at page number 80, passed by the honorable magistrate.
My lordship, I have the FIR copy, my lordship. And these five are the complainants.
Who are they?
Not five, my lordship. There are 13 members.
Whether this Measures Mayank Harshad Talati is one of the complainant?
No, my lordship. Mayank is not the complainant, my lordship.
Measures Harshad,
But it is not only Mayank Harshad Talati who has filed the NCLT petition, my lords. He is just the first person whose name is reflected.
My lordship, Srimati Keti Shah.
Ketki Shah Talati is his
Wife of
wife.
Malati.
She has filed the complaint insofar as
Wife
the.
of Mayank has filed the complaint, my lordship, not the Mayank. They have mentioned 13 people as an.
yes, what do you say?
My lordship, basically resolution profession is an authority appointed by the NCLT. my
He is
lordship.
just like a commissioner, court
Please, my
commissioner.
lordship, please.
Then
And also, if he has opened, on behalf of the complainant only, account has been opened, my lordship.
as per the
Directions of the NCLT.
he was
my lord.
appointed as per the directions of, as
NCLT,
per the order of NCLT.
Please, my lordship.
Then whether
He-
the
it-
imposition of such condition number 2 and 3 is necessary.
That is not, I feel, my lordship. But let the first condition be the,
First condition anyhow he has.
and
to
let
come.
him
Here in-
report like whenever he has,
Have you got the instructions from
please.
IO?
IO, I got it, but he was not aware. I have gone, met some other, I got regarding the NCLT procedures.
Could be allowed.
Yes, my lordship.
You have no dispute regarding the submissions made by him.
No, my lordship, no dispute. That is a part of the procedure of the,
What is this connected matter?
It is a very similar, my lord. Different company. I am the very same RP in that
So
also.
common order could be.
Common order.
Similar
Please, ma'am.
facts.
Please.
No change.
Similar facts, no changes. In fact, the complainants are also parallel complainants. Two companies they had invested in. Both of them are the same management.
Yes, common order will. be
Common
passed.
orders, please.
The petitioner's hearing. The petitioner is the same.
My lords.
Petitioner
Petitioner is the same. Petitioner company is different, represented by the same person.
the
Because company is say, a different juristic entity, my lord, it is petitioners are different.
Green Farm Tech Private Limited and ಅದರಲ್ಲಿ ಯಾವುದಿದೆ ನೋಡ್ಕೊಳ್ಳಿ. So also represented by resolution professional Mr. Jugraj Singh Bedi filed these petitions seeking issuance of writ in the nature of certiorari to set aside the conditions imposed in the order dated 23/2/2022 passed in crime number 90 of 2019 of which police station
that is CID, my lordship.
Basavangudi police station.
Basungudi Police Station.
Basavangudi police station registered for the offences
Under section 406 and 420, my lordship. Even the Delhi race.
IPC. Yeah, set aside the order dated 23/2/2022 passed in crime number so and so by the learned principal district and sessions judge while defreezing the bank account bearing bank account maintained at a Karnataka bank, Ansarovar Garden Branch, Delhi. Third so and so.
And then investigation was handed over to the economic offense branch, my lordship.
Economic offense branch of
CID Bengaluru.
Learned counsel for the petitioner contends
Economic offense division.
the
Division.
petitioner
Lordship.
company contended that there was several complaints against the petitioner company, and a few of the complainants have approached National Company Law Tribunal, NCLT for short,
Waves notice and then
alleging commission of offense and alleging various fraudulent acts. Considering the contentions taken by the complainants before NCLT, it has passed an order dated 20th February 2020 appointing Mr. Jugraj Singh Bedi, the petitioner herein, as resolution professional. It is the duty of the resolution professional to consider revival of the company by any possible means, to report to NCLT about any fraudulent activities that was undertaken by the company in the light of the allegations made by the complainants, and also to recommend liquidation of the company if the same could not be revived. Therefore, it is the contention of the petitioner that the resolution professional appointed by NCLT, who is representing the petitioner company, is a court commissioner appointed to take care of the company against which several allegations are made. As part of his effort to revive the company, the resolution professional opened an interim account with the Karnataka Bank so-and-so branch, Delhi, to have the transactions during the pendency of the matter before NCLT. Next part. It is contended by the learned counsel for the petitioner that one of the complainant before the NCLT has filed a criminal complaint with the Baswangudi police station, Baswangudi police, alleging commission of the offence punishable under section 406 and 450 of IPC. Accordingly, the FIR in crime number so and so was came to register. The investigating officer during investigation freezed the bank account opened by the resolution professional held with Karnataka Bank so and so Delhi. The resolution professional representing the company moved an application under section 451 and 457 of CRPC seeking defreezing of the bank account. The learned sessions judge allowed the said application defreeze the account, but he imposed the condition to execute the indemnity bond and surety bond for the amount standing in the account as on the date when the account was freezed and to offer bank guarantee. It also directed the applicant, who is the resolution professional, to undertake to make good the amount in the event of the applicant being found liable to pay the said amount and abide by the order of the court. The petitioner, now being aggrieved by the order, aggrieved by the condition number 2 and 3 imposed by the learned second sessions judge, is before this court. Next, according to the learned counsel for the petitioner, since the resolution professional is appointed by NCLT to take care of the petitioner company, has opened the interim bank account with Karnataka Bank so and so, which is the subject matter, which was freezed by the investigating officer. The court has rightly defreezed the account, but imposed condition number 2 and 3, which is not possible to comply with, since the resolution professional is a court commissioner for all practical purposes. He will act as per the directions of NCLT and hence pays for setting aside condition number 2 and 3. Learned HCGP on instructions submits that condition number 1 imposed by the learned sessions judge could be complied by the petitioner without any difficulty. However, she fairly concedes that condition number 2 and 3 could be relaxed, as the application was moved on behalf of the company by the resolution professional, who acts as a commissioner as per the directions of NCLT. Hence, she prays for passing appropriate orders. Value the materials. Point for consideration affirmative for the following reasons. It is not disputed that the petitioner company in both petitions are represented by resolution professional Mr. So and so, who is appointed as per the order dated 22/2020 passed by NCLT Bangalore branch. The order states that Mr. Jivraj Singh Bedi is appointed as the interim resolution professional, bracket IRP, to conduct the corporate insolvency resolution process, bracket CIRP, in respect of corporate debtor, namely Mrs. Green Farm Tech Private Limited and so Indian companies, and to carry out the functions as mentioned under I and B Code 2016 and the rules framed by the IBBI from time to time. Page number 63 nallide. Therefore, I do find a considerable force in the contention taken by the counsel for the petitioner that he acts as a commissioner appointed by NCLT in the form of resolution professional. The court, while defreezing the account, directed the resolution professional, who is representing the companies, to execute the indemnity bond and to offer bank guarantee, and also to undertake to make good the amount in the event he is found liable to pay the same. Since the interim resolution professional is appointed by NCLT, and it is stated that as per the direction, as part of his duty, he has opened the bank account with Karnataka Bank so and so, and that the resolution professional is duty bound to abide by the conditions that will be imposed, duty bound to comply with the directions issued by NCLT to revive the company and to report regarding any fraud that is committed by the company or to suggest to liquidate the company if the same could not be revived. I am of the opinion that the condition number 2 and 3 imposed by the court below may not be relevant in the present case under the given facts and circumstances. But you may have to file an undertaking before the
Trial court.
trial court
Yes.
to act as per the directions of NCLT.
To act as per the idea, yeah, I will do so, my lords. Anyway, I am bound by it.
Yes,
No, that can also be recorded also. That I will act as per the instructions of Honorable
because
NC.
I have recorded your oral submission
Please.
that you are acting as per the directions of NCLT.
Yes.
Give an undertaking to
Yes, my lords.
before the trial court
Yes.
that you will act
My
as
lords,
per the,
in fact, if that is the case, we can even submit it here because, my lords, insofar as the sessions court is concerned, where the crime is going on, there, my lords is asking me to file an undertaking.
I will file it
I will do so.
in Bantu. I deem it appropriate to direct the resolution professional representing the petitioner companies to give an undertaking before the learned sessions judge that he will abide by the directions given by NCLT and discharge his duties strictly in accordance with law in maintaining and operating the bank account concerned. That will definitely take care of the interest of the prosecution, the interest of the investigating officer oblique prosecution. Hence, in view of the above, I answer the above point in the affirmative and proceed to pass. The petition is allowed. Condition number 2 and 3 imposed with a order dated 23/2/2022, passed in crime number 1919 of Baswangudi Police Station, Bengaluru, by the learned principal city civil and sessions judge, Bengaluru, is set aside. Instead, the applicant who is representing the petitioners in these petitions shall file an undertaking before the sessions court, declaring that he is acting as per the directions of the National Company Law Tribunal, Delhi, Bangalore branch, as per its order dated 20/2/2020, and that he will abide by the directions and the conditions that will be imposed by NCLT in the matter of maintaining and operating the bank account concerned. Yes. Petition is allowed subject to that condition. file a,
My lords, one request. It may specifically be recorded and a direction may be given saying that the minute we file that, the account may be released because it's a 2022 matter. This is stalling the.
the moment the applicant representing the petitioner's hearing submit such an undertaking before the learned sessions judge, comma, the bank account concerned shall be defreezed forthwith. Yes.
Grateful.
For admission matter, serial number 12, Sidmalappa PM.
Lordship, I represent for respondent 218.
This case, appear for petitioner, please, Lordship.
Yes.
Petitioner is accused number 1 and 2 in CC number 771 bar 2016, please, Lordship.
In all, how many accused are there?
Totally four
Five.
accused.
5.
What are the offense?
363, please, Lordship. There is a complaint registered by one Savitri. She is a wife of second respondent hearing. She lodged the complaint on 16/5/2000.
She is not a party,
She is,
then why? There are two complainants.
Allah, second respondent is the complainant. The third respondent is the saying a victim person, he was kidnapped by the accused person. On the basis of his statement,
As per your cost title, complainant number 1 and 2.
adರಲ್ಲಿ he largely, two statements are there, please, Lordship.
This respondent number 3 was kidnapped
Please, Lordship.
and
Yeah.
respondent number 2 filed the complaint.
Filed the complaint on 16/5/2015.
Date of incident,
Date of incident is on 16/9/2015.
date of complaint,
On the same day, 16/9/2015, at about 11:15 PM. I request this honorable court, please, Lordship. In page number 76, the third respondent given a two statements before the police. The
Now
first statement,
investigation is completed.
please, Lordship, investigation is completed, charge sheet was filed in CC number 771/2016,
CC number,
771/2016.
before which court?
Principal Civil Judge, JMFC, Nelamangala.
What is the stage before the trial court?
It is for, as per my knowledge, please, Lordship.
For accused number 192, EP has been filed and 325 NBW has been issued, my lords.
Charge is not yet framed.
Charges not.
Not at frame, please, Lordship. I request,
NBW was issued against? accused?
3 and 5 accused,
3 and 5.
please.
I request this honorable court, in page number 71, complaint lodged by one Savita, TR Savita. It is typed copy is in page number 71, please, Lordship.
No, why you are seeking quashing of the criminal proceedings?
There is the two statement given by the respondent number 3, please, Your Honor. There is a civil dispute between the first petitioner and the respondent number 3. The original suit is pending before the.
Maybe. Can it be a ground for kidnapping?
Allah, first instance, he has given a statement saying that there is no kidnap at all. It is only a conversation, talk with the accused person with regard to property is concerned. Subsequently, after lapse of 5 days, please, Lordship, he given a further improvement statement. I request this honorable court, page number 76 is the first statement given on 17/9/2015.
Further statement is to be taken into consideration. Can
Here,
it be ignored at this
Allah,
stage?
my humble submission before this honorable court, Lordship.
Hmm.
Here, the first, he says that he is traveling in a KA 52 M 3066 Desire vehicle, car.
Hmm.
Maruti Desire car. Maruti Desire car was not seized.
ಅದೆಲ್ಲ ಇರ್ಲಿ, ಅದೆಲ್ಲ that cannot be the ground for quashing, sir.
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ
Lapse in the, on the part of the investigating officer,
Yes.
cannot be the ground for quashing.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ what will happen, first instance he has says before the police itself. I request this honorable kindly, sir, in page number 76, please, sir, for a moment. It is last ಕೆಳಗಡೆಯಿಂದ 5ನೇ ಲೈನ್ ಅಲ್ಲಿ ಸೊ ದೊಡ್ಡಬೇಲೆ ಗ್ರಾಮಕ್ಕೆ 6 ಗಂಟೆಗೆ ಹೋಗಿ ನನ್ನ ಹೆಂಡತಿಯನ್ನು ತವರು ಮನೆಯ ಬಳಿ ಇಳಿಸಿ ನಾನು ಮನೆಗೆ ವಾಪಸ್ಸು ಊರಿಗೆ ಬರಲು ಕಾರನ್ನು ತ್ಯಾಮಗಂಡು ತೋಟನಹಳ್ಳಿ ಮಾರ್ಗವಾಗಿ ಬರುತ್ತಿದ್ದಾಗ ತೋಟನಹಳ್ಳಿ ಬಂಡೆಯಿಂದ ಸ್ವಲ್ಪ ಕೆಳಗೆ ಆಲಿ ಬ್ರಿಕ್ ಫ್ಯಾಕ್ಟರಿ ಬಳಿ ಬಂದಾಗ ಎಂ ಗಾಂಧಿ ಪ್ರಕಾಶ್ ಮತ್ತು ಇನ್ನಿಬ್ಬರು ಬಂದು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಜಮೀನು ವಿಚಾರದಲ್ಲಿ ವ್ಯವಹಾರ ಮಾತನಾಡಲು ಹೋಗಿದ್ದು ನನ್ನ ಹೆಂಡತಿ ನನಗೆ ಫೋನ್ ಮಾಡಿದಾಗ ನಾನು ನನ್ನ ಫೋನನ್ನು ತೆಗೆಯಲೇ ಫೋನ್ನಲ್ಲಿ ಮಾತನಾಡದಿರುವುದರಿಂದ ನನ್ನ ಹೆಂಡತಿಗೆ ಅನುಮಾನ ಬಂದು ನಾಗರಾಜ್ ಮತ್ತು ಇತರರು ನನ್ನನ್ನು ಅಪಹರಣ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ದೂರು ನೀಡಿರುತ್ತಾರೆ. He is aware of that fact. ನಾನು ನಾಗರಾಜ್ ಗಾಂಧಿ ಹಾಗೂ ಇತರರು ಜಮೀನ ವ್ಯವಹಾರದ ವಿಚಾರದಲ್ಲಿ ಮಾತುಕತೆ ಆದ ನಂತರ ನನ್ನನ್ನು ದವಾಸ್ಪೇಟೆ ಬಸ್ ನಿಲ್ದಾಣಕ್ಕೆ ಬಿಟ್ಟು ಹೋಗಿರ್ತಾರೆ. ನನ್ನ ಹೆಂಡತಿ ನೀಡಿರುವ ವಿಚಾರದಲ್ಲಿ ನಾನು ಈ ದಿವಸ ಠಾಣೆಗೆ ಬಂದು ನನ್ನ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತೇನೆ. This is the version he has stated that there is no kidnap.
No kidnap ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೂ ಫೋರ್ಸಬಲಿ there is no force at all.
Reading that, you are saying that.
ಅಲ್ಲ he himself is saying that.
ಎಲ್ಲಿಂದ ಹೇಳಿ ಸರ್?
ಅದನ್ನೇ ನಾನು ಓದಿದ್ನಲ್ಲ ಸ್ವಾಮಿ, 6 ಗಂಟೆ ಗ್ರಾಮಕ್ಕೆ ಹೋಗಿ
ಇನ್ನು 10 ಸಲ ಓದಿದ್ರು ನಾ ಕಿಡ್ನಾಪ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಅವ್ರು.
ಅಲ್ಲ ಕಿಡ್ನಾಪ್ ಅಲ್ಲಲ್ಲ
ಮಾತುಕತೆಗೆ ನನ್ನನ್ನು ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಮಾತುಕತೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಅಂತ. ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್,
ನಿಮ್ಗೂ ಬರುತ್ತೆ.
my humble submission, the kidnap has to be forcibly has to be taken. And subsequent statement after lapse of 5 days, please lordship.
Yes.
The second statement was given. It is in page number 79. ಅದರಲ್ಲಿ ಎಲ್ಲಾ ರೀತಿಯಲ್ಲೂ ಬರುತ್ತೆ. In page number 79, please lordship.
Page number
79. Typed copy in page number 82. Typed copy ಅಲ್ಲಿ please lordship. Bottom in the 8th line, same. ಗ್ರಾಮಕ್ಕೆ ದೊಡ್ಡಬೇಲೆ ಗ್ರಾಮಕ್ಕೆ 6 ಗಂಟೆಗೆ ಹೋಗಿ ನನ್ನ ಹೆಂಡತಿಯನ್ನು ತವರು ಮನೆಯ ಬಳಿ ಇಳಿಸಿ ನಾನು ಮನೆಗೆ ಹೋಗದೆ ವಾಪಸ್ ಊರಿಗೆ ಬರಲು ಕಾರನ್ನು ತ್ಯಾಮಗೊಂಡು ತೋಟನಹಳ್ಳಿ ಮಾರ್ಗವಾಗಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದಾಗ ತೋಟನಹಳ್ಳಿ ಬಂಡೆಯಿಂದ ಸ್ವಲ್ಪ ಕೆಳಗೆ ಆಲೋಬ್ಯಾಕ್ ಫ್ಯಾಕ್ಟರಿ ಬಳಿ ಬಂದಾಗ ನನ್ನ ಕಾರಿನಿಗೆ ಎಂ ಗಾಂಧಿ ಪ್ರಕಾಶ್ ಹಾಗೂ ಇನ್ನಿತರ ಅಪರಿಚಿತರು ಮಾರುತಿ ಶಿಫ್ಟ್ ಕಾರನ್ನು ಅಡ್ಡ ಹಾಕಿದರು. ನಂತರ ಗಾಂಧಿ ಅವರು ನಮ್ಮ ಕಾರಿನ ಹತ್ತಿರ ನನ್ನನ್ನು ಎಡಕ್ಕೆ ತಳ್ಳಿ ಡ್ರೈವಿಂಗ್ ಶೀಟ್ನಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಪ್ರಕಾಶ್ ಮತ್ತು ಇನ್ನಿತರ ಅಪರಿಚಿತರು ನನ್ನನ್ನು ಹಿಡಿದುಕೊಂಡು ಹಿಂಭಾಗದ ಶೀಟಿನಲ್ಲಿ ಕುಡಿಸಿಕೊಂಡು ಕಣ್ಣಿಗೆ ಬಟ್ಟೆ, ದಿಸ್ ಅ ವೆರಿ ರಿಲೆವೆಂಟ್ ಪ್ಲೀಸ್, ಕಣ್ಣಿಗೆ ಬಟ್ಟೆ, ಬಾಯಿಗೆ ಬಟ್ಟೆಯನ್ನು ತುರುಕಿ ನನ್ನನ್ನು ನನ್ನ ಕಾರಿನಲ್ಲೇ ಹೈವೇಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ಬಿಲ್ಲನಕೋಟೆಯಿಂದ ದವಾಸ್ಪೇಟೆ ಕಡೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ದವಾಸ್ಪೇಟೆಯಿಂದ ಎಡಕ್ಕೆ ಜಂಗಲ್ ರಸ್ತೆಯ ಮನೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಒಂದು ತೋಟದ ಮನೆಯಲ್ಲಿ ಕೈ ಕಾಲುಗಳನ್ನು ಹಗ್ಗದಿಂದ ಕಟ್ಟಿ ಕೈಗಳನ್ನು ಹಿಂದಕ್ಕೆ ಕಟ್ಟಿ ಒಂದು ದಿವಾನ್ ಕಾಟ್ ಮೇಲೆ ಹಾಕಿದರು. ಹಿಯರ್ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಶಿಪ್. He says that ಕಣ್ಣು ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಯಾತೂ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ he is explain everything in map. ಎಲ್ಲೆಲ್ಲಿ ಯಾವ ಕಡೆಯಿಂದ ರೋಡು ಕಣ್ಣು ಕಟ್ಟಿದ್ರು ಆತಂಗೆ ಎಲ್ಲ ಯಾವ ರೋಡಲ್ಲಿ ಹೋದ್ರು ಯಾವ ಜಾಗದಲ್ಲಿ ಹೋದ್ರು ಎಲ್ಲ ಹೇಳ್ತಾರೆ. This is a improved statement. ಅಂಡ್ ಅಲ್ಲಿಯೇ ವಿ ನಾಗರಾಜ್ ಅವರು ಬಂದು ಮಚ್ಚನ್ನು ಅವರ ಕೈಯಲ್ಲಿ ಹಿಡಿದುಕೊಂಡು ಒಡೆಯುವುದಕ್ಕೆ ಮೇಲಕ್ಕೆ ಎತ್ತಿದರು. ಸೋನ್ಸೋ ನಿನ್ನನ್ನು ಕತ್ತರಿಸುತ್ತೇನೆ ಅಂದರು. ನಾಗರಾಜು ಮಚ್ಚನ್ನು ಜೊತೆಯಲ್ಲೇ ಇದ್ದ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿಗೆ ಮಚ್ಚನ್ನು ಕೊಟ್ಟರು. ನಂತರ ನನ್ನ ಕೈ ಕಾಲು ಕಟ್ಟಿದ್ದ ಹಗ್ಗವನ್ನು ಬಿಚ್ಚಿದರು. ನನಗೆ ನೀರನ್ನು ನಾಗರಾಜು ಕುಡಿಸಿದರು. ನನ್ನ ಆಸ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಇಸ್ ಅ ವೆರಿ ರಿಲೆವೆಂಟ್ ಯುವರ್ ಆನರ್. ವೈ ಆಮ್ ಪ್ರೆಸ್ಸಿಂಗ್ ದಿಸ್ ಅ ಸಿವಿಲ್ ಸೂಟ್. He has elicited all those facts in the further statement. ಕಟ್ಟಿದರು. ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ 86/6 ಹನುಮಂತಪುರ ಸರ್ವೆ ನಂಬರ್ 57/1 ಹಾಗೂ ಇತರೆ ಶಿರಾ ತಾಲೂಕು ಬುಕ್ಕಾಪಟ್ಟಣ ಹೋಬಳಿ ಚಿಕ್ಕ ಅಗ್ರಹಾರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 38/3, ಶಿರಾ ತಾಲೂಕು ಕಳ್ಳಂಬೆಳ ಹೋಬಳಿ ತರೂರು ಗ್ರಾಮದ ಸರ್ವೆ.
Suit that is pending.
Their suit for specific performance is pending. I produced the plain copy, your lordship, page number 50. It is against the third respondent with respect to agreement is concerned.
His suit was
OS
filed-
number
OS number 732/2015, filed by the first petitioner V. Nagaraju.
against
Against the third respondent, please, lordship, Rajanna.
And subsequently, respondent 2 was also implemented, my lord.
yes
This suit was filed in December 9/12/2015.
In this case,
9/12/15.
15.
ಇರಿ ಸರ್, ನಾನು ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ನೀವು ಮಾಡಂಗಿದ್ರೆ ನಾನು
This
ಸುಮ್ಮನೆ.
suit is still pending.
Suit is still pending. The on base of the said suit, please, your honor, agreement dated 3/5/2014. It was executed by the third respondent in favor of the first petitioner. I have produced the agreement copy before this honorable court, please, lordship, in page number 60. In that agreement, please, lordship, he has received 90 lakhs. And 10 lakhs is a balance. On the basis of that,
No, complaint was filed much earlier.
the complaint filed in 16/9/2015, please, lordship.
You filed the suit in the month of December.
Please.
So subsequent, suit is subsequent.
But agreement is much earlier, 1 year back, please,
But you
lordship.
had not filed any suit at that time.
Alla, that time I am not filed.
Yes,
On,
that is the only ground.
in the civil suit on ground, please, your lordship. And second ground,
At the time of filing the complaint, there was no suit.
Allah, my humble submission before this lordship, I may be permitted to read the further statement of the Rajanna. He reflect the same. ಅಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ ಅವರುನು.
ಅದೇ ರಾಜಣ್ಣನೇ, that is respondent number 3.
3.
Yes.
ಅವ್ರು ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಇಲ್ಲಿ ಇನ್ ಪೇಜ್ ನಂಬರ್ 84, ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಶಿಪ್. ಇದರಲ್ಲಿ ನಾನು ಸರ್ವೆ ನಂಬರ್ 58/1 and survey number 12, survey number 113, survey number 12 and survey number 145 ಅದ್ರ ಬಗ್ಗೆ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಇನ್ ನೆಕ್ಸ್ಟ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 84 ಅಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ, ಪ್ಲೀಸ್. Why he has not given a statement in earlier point of time, 5 days earlier. ನಂತರ ನನ್ನ ಹೆಂಡತಿ ಶ್ರೀಮತಿ TR ಸವಿತಾ ಅವರು ನನ್ನ ಗಂಡನನ್ನು ನಾಗರಾಜು ಹಾಗೂ ಇತರರು ಸೇರಿ ಅಪಹರಣ ಮಾಡಿಕೊಂಡು ಹೋಗಿರ್ತಾರೆಂದು ದೂರು ಕೊಟ್ಟಿರುವ ವಿಚಾರವನ್ನು ಫೋನ್ ಮೂಲಕ ತಿಳಿದುಕೊಂಡು ನನ್ನನ್ನು ಸಾಕ್ಷಿ ತಿಳಿಯದೆ ಹಾಗೆ ಎಲ್ಲಿಯಾದರೂ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಕತ್ತರಿಸಿ ಹಾಕಿ ಚಿರತೆ ತಿಂದು ಹೋಗುವಂತೆ ಮಾಡೋಣವೆಂದು ಮಾತನಾಡಿಕೊಂಡಿದ್ದರು. ನಂತರ ದೂರು ನೀಡಿರುವ ಬಗ್ಗೆ ವಿಚಾರ ತಿಳಿದು 16/9/2015 ಅದೇ ದಿನ ರಾತ್ರಿ 1:30 ಗಂಟೆಗೆ ನನ್ನನ್ನು ದವಾಸ್ಪೇಟೆ ಠಾಣೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ನನ್ನನ್ನು ಕಾರನ್ನು ದವಾಸ್ಪೇಟೆ ಬಸ್ ನಿಲ್ದಾಣದ ಬಳಿ ಬಿಟ್ಟು ಪೊಲೀಸ್ನವರಿಗೆ ಈ ವಿಚಾರ ತಿಳಿಸಿದರೆ ನಿನ್ನ ಹೆಂಡತಿ ಗಂಡನಿಲ್ಲದಂಗೆ ಮಾಡುತ್ತೇವೆ ಎಂದು ಎದೆಸಿದ್ದರಿಂದ ನಾನು ವಿಚಾರವನ್ನು ಯಾರಿಗೂ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ಅ ವರ್ಷನ್ ಯುವರ್ ಆನರ್ he has stated, but he has given a statement before the police on 1:30 PM on the same day. ಮತ್ತೆ ಜಮೀನಿನ ದಾಖಲಾತಿಯೊಂದಿಗೆ ನೆಲಮಂಗಲ ಬ್ರಾಂಚ್ ಚೆಕ್ ನಂಬರ್ ಸೋನ್ಸೋ 2 ಚೆಕ್ಗಳು 4 ಖಾಲಿ ಸಹಿ ಮಾಡಿರುವ ಚೆಕ್ಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡಂತೆ ನನ್ನ ಹೇಳಿಕೆಯಾಗಿರುತ್ತದೆ. ನನಗೆ ನಾಗರಾಜು ಮತ್ತು ಆತನ ಸಹಚರರು ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ಜಮೀನಿನ ವ್ಯವಹಾರವನ್ನು ನಾವೇ ಕುಳಿತು ರಾಜಿ ಮಾಡಿಕೊಳ್ಳೋಣ ಎಂದು ತಿಳಿಸಿದ್ದರಿಂದ ತನಿಖಾಧಿಕಾರಿಗಳ ಮುಂದೆ ಹೇಳಿಕೆ ನೀಡುವಾಗ ಈ ಹೇಳಿಕೆ ನೀಡಿರುವುದಿಲ್ಲ. ನಾನು ಹೇಳಿರುವ and in this statement, please lordship, he is explained that he has forcibly has taken a signature of the respondent number 3 with typed copy and with blank papers. And I request this honorable court, your honors, they have taken a ground in the written statement on the same version. They have taken a written statement ground, please, your lordship. Execution of the sale agreement is forcibly they have obtained the signature of the respondent number 3. I request I produce the written statement filed by the respondent number 3, please, lordship.
Yes, what do you say?
Please, my lords, total investigation has been completed, my lords, and charge sheet has been filed against accused number 1 to 5. My lords, in this case, no doubt, as the learned counsel for petitioner is pleading that there is a civil dispute with respect to some properties and all, my lords. But civil dispute will now not give a license to kidnap some person to obstruct
He
him.
has not stated in the first statement.
My lords,
What prevented him?
my lords, he might be have apprehended, my lords, the trauma.
Not the case. That is not stated in the second statement also.
Please, my lords, but he has never ever stated anywhere that he has not been kidnapped. He has
ಮಾತುಕತೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು ಅಂದ್ರೆ
He has stated, but karkond ಹೋಗ್ಲಿಕ್ಕೂನು at least that should not be.
voluntarily he has gone. ಬಲವಂತವಾಗಿ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಇಲ್ಲ. That amounts to
My
kidnapping.
lords, but there are so many contradictions in one comparatively one to another statement.
Some
my
reasonable
lords.
explanation why that first statement was given.
My lords, CW2 happens to be the wife of
She is
CW2.
not an eyewitness.
She is not an eyewitness, as her husband did not turned up
And
in spite of
this
her calls.
Respondent number 3 specifically states, only on suspicion the complaint was came to be filed.
Please,
But I will,
at the initial stage, he has stated like that, but in the further statement,
why that is so?
my lords, he might have an apprehension of being
Who has
killed.
to say that?
He only has to say
He has never stated so.
this.
Then
But my lords,
what do you say?
Lord, much before this complaint, there was one more complaint filed by the
There
respondent.
may be multiple complaints, sir.
No, my lord.
What is your
Specifically,
explanation
that-
regarding
that-
first statement?
First statement, not she was not knowing about her.
She
husband's
alone,
wife.
Rajanna, respondent number 3 has given this statement.
True, my lord. On that day, I may be permitted to read few paragraphs. my lord.
ಆಯ್ತು ಎಲ್ಲ
Their own
ಓದಿದ್ದಾರೆ.
document, page number 82, my lord. ಅದೆಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ. ಸಂಜೆ ಫ್ರಮ್ ಸೆವೆಂತ್ ಲೈನ್ ಮೇಲೆ ಸಂಜೆ 7ಗೆ ನಮ್ಮ ಮನೆ ಹತ್ತಿರ ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಬಿಟ್ಟು ನನ್ನ ಮತ್ತು ಮಾರುತಿ ಶಿಫ್ಟ್ ಡಿಸೈರ್ ಕಾರಲ್ಲಿ KA 52 M3066 ಕಾರಲ್ಲಿ ಹೊರಟು ಕಸರಘಟ್ಟಕ್ಕಾಗಿ
Why you are reading that? I have already heard he has read
Please,
it.
my lord.
Then
I was forcibly taken. At the 9th point, I was forcibly taken. Then, my lord.
sir, I am
the petition-
asking the explanation why you have given first statement.
First complaint, my lord, as on day, they left me after 3 days, my lord. I was in the wrong.
Immediately when the investigating officer comes, definitely he would have stated.
Certainly, my lord.
Then
On that day.
if
I
he was kept kidnapped and kept in the captive position for 3 days, why he will say ಮಾತುಕತೆಗೆ ಹೋಗಿದ್ದೆ ಮಾತುಕತೆ ಮಾಡಿ ಬಂದೆ ನನ್ನ ಹೆಂಡತಿ ಅನುಮಾನಗೊಂಡು ಫೈಲ್ ಮಾಡಿದ್ರು? Who will say that?
That statement was literally given to the police station. Then another statement, they had called me.
That cannot be, sir. At your whims and fancies, you cannot give this statement.
The few documents, my lord, I may be permitted to. I have done. This petitioner-
And it is your contention that you went there to drop your wife,
Please, my lord.
right? Why any person will carry all the original documents with him?
My lord, it's not the original documents, my lord.
Then
They
the
made
second
me to
statement
sign-
says so.
They made me to sign blank papers.
And
their
taken
custody.
the ಮೂಲ ದಾಖಲಾತಿ ಏನೋ ಇದೆಯಲ್ಲ.
Please, my lord.
Also,
Who will take that? ಕಾರ್ನಲ್ಲೆಲ್ಲ ಅವ್ರು ಕಿಡ್ನಾಪ್ ಮಾಡ್ತಾರೆ ಅಂತ ಎಲ್ಲ ರೆಡಿ ತಗೊಂಡೋಗಿರ್ತಾರ?
As I admit, my lord, there was transaction with the petitioner.
No, very suspicious circumstances.
I admit that there was a transaction with the petitioner
No,
with regarding to some mobile properties. And I happen to be a realtor. I have documents.
who will carry these documents in the car, sir? When you went to drop your wife to her parents' house? Will it not give a reasonable suspicion?
Now, usually I carry all the documents, my lord.
Okay. So wherever you go, you go with the documents.
No, it's not like that, my lord.
Then
That day I had
there must be
some
reasonable explanation. No. No,
I mean, this petitioner.
serious
is not
doubt
a-
arises.
Lord, this petitioner is not an ordinary person. my lord.
ಈಗ ಇದು
Both are not ordinary, sir.
duplicate document ಮತ್ತೆ.
ಮೂಲ ದಾಖಲೆಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ನನ್ನಿಂದ ಕನ್ನಡದಲ್ಲಿ ಹಾಗೂ ಇಂಗ್ಲಿಷ್ನಲ್ಲಿ ಸಹಿ ಪಡೆದು ಎಡಗೈ ಹೆಬ್ಬೆಟ್ಟಿನ ರುಜು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. Can it be believed?
And this civil suit is filed subsequent.
And
to this
obviously, this allegation is made, according to him, the agreement to sell is dated 3/5/2014. Even though the suit was filed on 9/12,
December.
agreement is dated 3/5.
That suit is not filed by me.
Obviously,
filed by the
that statement is given for this purpose. Prima facie, that is the impression.
Lord, and this petitioner is not a law-abiding citizen. my lord.
You
Furnished to documents.
you defend the suit, not the criminal proceedings, no. Prima facie, it is an abuse of process of law.
After one submission, my lord, as soon as the original suit for specific performance was filed, they obtained the interim order.
Hmm.
After obtaining
It is
interim
for the
order-
civil code. It will take care of that.
Please, my lord.
I am not concerned about that. What the order will be passed by the civil court, what the evidence you will lead, what the decree that will be passed by the trial court.
Other
It
complaint
is none of my concern.
Other complaint is not raised in the petition.
No, this is not the case. No. Covered.
Those documents which I am only copies of, my lord, not the original.
Serious doubt arises, sir. Covered. The petitioners being
My
accused numbers.
permitted to read the complaint, my lord.
ಎಲ್ಲ ಓದಿ ಆಗಿದೆ ಸರ್.
ಅಲ್ಲ,
ಅದೇ ಮತ್ತೆ ಏನು you are wasting the time, that's all. That will not make out any ground. The petitioners being accused numbers 1 and 2.
One
In,
permitted to read one complaint of the respondent number 3.
sir, let there be 100 complaints. I am not concerned. I am concerned about this case. There are material contradictions in the first statement and the second statement. There is no reasonable explanation for the same. The conduct of respondent number 3 gives rise to a serious doubt.
Carrying the documents.
Yes.
Xerox copies of the
ಆಯ್ತು,
documents.
civil suit ನಲ್ಲಿ you defend the suit.
And seriously, I was taken with a
In,
knife point. I was
crime
dragged in the
number.
car, my lord.
No, I am not here to accept that, sir.
One other complaint before this complaint may be permitted. to
That
read,
will
my
not improve your case in any manner.
lord.
Crime number
This
250.
happens to be a-
Please, it is enough, sir. 254 of 2015 of Dabaspet Police Station, registered for the offence punishable under section 363, read with 149 of IPC, which was later registered in CC number 771 of 2016, pending on the file of the learned civil judge, principal civil judge in JMFC Nalmangala. Is seeking to quash the criminal proceedings initiated against them. Heard so and so, affirmative for the following reasons. Respondent number 2 being the wife of respondent number 3 filed the first information with the Dabaspet Police Station on 16/9/2015, alleging that her husband respondent number 3 was kidnapped by where is the FIR? Page number?
The FIR is in page number 72, please, Lordship.
Got it.
Annexure G.
By accused numbers 1 to 6.
One to five, please, Lordship. 6 is unknown persons.
ಇಲ್ಲ ರಂಗಣ್ಣ ಅಂತ ಇದೆ.
KC Rangana, I'm sorry.
ಹೆಸರೇ ಇದೆಯಲ್ಲ.
KC Rangana, I'm sorry.
Accused numbers 1 to 6, kidnapped respondent number 3. As he was not reachable, as he has not picked up her call, she came to know that the accused have kidnapped respondent number 3. She has given the details of the persons who have kidnapped. The wife is not the eyewitness to the incident, no, but she gives chehre. ಯಾರ್ಯಾರು ಕಿಡ್ನಾಪ್
Based on
ಮಾಡಿದ್ದಾರೆ
past
ಅಂತ.
incidents, she gives a complaint. my lord. Crime number 237 of 15.
Suspicion
Before the
ಅಲ್ಲಲ್ಲ.
same police station, against the same
ಅಪಹರಣ
petitioner.
ಮಾಡಿದ ವ್ಯಕ್ತಿಯ ಚೆಹರೆ 5 ಅಡಿ 6 ಇಂಚು ಎತ್ತರ, ಸಾಧಾರಣ ಮೈಕಟ್ಟು, as if she is the eyewitness.
My lord, based on the same earlier incident, that case.
On the basis of this information, the FIR was going to be registered
Try number.
and the
237 of
investigation
50,
was
my lord.
undertaken. The investigation is completed and charge sheet came to be filed against accused numbers 1 to 5 for the aforesaid offences. The learned magistrate took cognizance of the offence and registered CC number so and so 771 of 2016. He stated that now the matter is pending for hearing before charge and also production of accused number 3 and 5 under NBW. In the meantime, the petitioners, being accused numbers 1 and 2, have approached this court seeking to quash the criminal proceedings. Next paragraph. Counsel for the petitioner drawn the attention of the court to the statement given by respondent number 3, the investigating officer, on 17/9/2015. As per this statement, respondent number 3 categorically states that he had brought his wife, that is respondent number 2, to her parents' house, and while returning, he met the accused and had gone with them for discussion with regard to the immovable properties. In the meantime, he was called by respondent number 2 over phone. Since he had not picked up the call, on suspicion, his respondent number 2 filed the complaint. Strangely, on 22/9/2015, respondent number 3 has given his second statement before the investigating officer, specifically stating that he was kidnapped forcibly by the accused. He was blindfolded, tied his limbs, taken to a deserted place, gave life threat, got his signatures both in Kannada and English, and his thumb impression on the document. He also states that the original documents pertaining to the property were also taken by the accused. Thereby, respondent number 2 gives a detailed version of his kidnap only on 22/9/2015, when the incident had occurred on 16/9/2015, and his first statement was recorded on the very next day, that is on 17/9/2015. If these first and second statements of respondent number 3 given before the police are taken into consideration, one cannot be reconciled with the other. There is absolutely no explanation as to why respondent number 3 at the first instance has given a statement giving clean chit to the accused, stating that he had gone with the accused for discussion regarding his landed property, and his wife, respondent number 2, had filed a complaint only on suspicion, but proceeded to give a detailed version of the criminal offence said to have been committed by the accused only on 22/9/2015. Next paragraph. It is specifically stated by respondent number 3 that he had gone to drop his wife to her parents' house. While returning, he was kidnapped. But the allegation is that even the original documents pertaining to these landed properties were taken away by the accused. There is no reasonable explanation as to why respondent number 3 had carried the original documents of his properties along with him in the car on the date of incident. Next paragraph. It is brought to the notice of the court that the petitioner, who is the plaintiff in the suit,
Please, Lordship.
732.
Please,
Accused
Lordship.
number 1.
First petitioner is the plaintiff.
It is brought to the notice of the court that accused number 1, petition number 1, had filed the suit was 732 of 2015 before the trial court against respondent number 3 seeking specific performance of contract on the basis of an agreement dated 3/5/2014 said to have been executed by respondent number 3 in his favor. Even though the said suit was came to be filed on 9/12/2015, the agreement relied on by accused number 1 is dated 3/5/2014. If this fact is taken into consideration in the light of the inconsistent statement given by respondent number 3 and specific allegations made by respondent number 3 in his second statement that was recorded on 17/9/2015, on 22/9/2015, I do find considerable force in the contention taken by the learned counsel for the petitioner that deliberately a complaint was came to be filed making allegations against the petitioners to have a defense in the civil suit that is pending for consideration. Obviously, prima facie, I am of the opinion that to settle the civil dispute, a criminal case was came to be registered by abuse of process of law. Therefore, the criminal proceedings against the petitioners is liable to be quashed. Accordingly, I answer the above point in the affirmative and proceed. Petition allowed.
Grateful.
Next.
Serial number 13, Rajshekar S.
Sir, my apologies, my lords, on the last date, my lords, when my lords
CRPC. Yes,
lords disposed of this matter, I tried to, my lords, interpret one section.
yes,
My lords directed me to produce two documents.
yes.
In spite of my repeated intimation to
Need not be, need not have the trouble, take the trouble.
my lords,
CRPC contains the format of NBW.
my lords, I saw that, my lords, so I'll accept that
There is a
judgment.
direction.
I'll-
You should produce the accused before this court.
That's right. I accept that judgment, my lords, whatever, my lords.
No, judgment alone, sir. Format is there.
I saw that, my lords. I said, my lords, I'm ready to accept the verdict of this
Yes.
honorable court.
So are they final?
Ade. My apologies for having tried to interpret that, my lords, in a
It's all
different
right,
manner.
it's all right. You have made your efforts. That's all.
Please, my lords.
So are they, first
Please,
petition. Petition dismissed. Observations made about Bandira. Yes,
Grateful.
yes.
Serial number 14, Abhishek K.
Appear for petitioner. The petitioner counsel is not keeping well. A short accommodation will be given. I inform complainant counsel.
Filing of color.
Venkatesh sir, I inform.
Venkatesh Bhatti has not filed wakalat. Has filed?
Already.
Already filed? It is stated that Sri Venkatesh Bhatti, Learned Counsel, has already filed wakalat for respondent number 2. Office is directed to take note of the same. Counsel for the petitioner, praise time. Next. I ಮಾಡ್ತಾರೆ.
An interim order may be extended, Your Lordship.
Extend. Next.
Serial number 15, Nagendra Naik R.
Short accommodation, my senior is
Hmm?
senior is inconvenience, my season is not well. Kindly, tomorrow level listed, madam.
Counsel for the petitioner, praise for, tomorrow ಎಲ್ಲ ಆಗಲ್ಲ sir. Counsel for the petitioner, praise time. Who moved the matter?
Because the respondent, the urgency, my lord, interim order is being operated in Lord since for the past 4 years. Tomorrow or day after tomorrow, my lord.
Yes, day after tomorrow they will senior. Day after
Both the
tomorrow.
learned
Matter, my
counsel
lord.
undertake to address their arguments on the next date of hearing without fail. Submission is placed on record, list finally as a last chance. No further adjournment. sir.
Yes, madam.
Date ಕೊಡಿ ಅವರಿಗೆ, convenient date, short date ಕೊಡಿ. Next.
12th.
Much.
Serial number 16,
My lord.
S. Mohan Kumar.
My last 13th, my last senior 12th is there, 3 special court matters is there.
ಮತ್ತೆ ಬಂದು pass
ಇಲ್ಲ,
over.
no, madam, 13th final, my lord.
Yes,
13th, my lord.
13.
Much of that.
Serial number 16, H. Mohan Kumar.
I appear for the petition. Well, I pray for a short accommodation.
Why, sir?
Haven't gone through the papers.
2022 matter for years ಆಗ್ತಾ ಇದೆ. ಇನ್ಯಾವಾಗ you will go through the counsel for the petitioner praise time. Next.
Interim order, there is an interim order.
Extend,
Serial number 17, Kolli Anand Rangappa. Serial number 17.
Counsel for the petitioner is absent, no representation. IA 1 of 2025 is filed seeking vacating of the stay. In spite of that, there is no representation. List on extended mark.
In 17.1.
17.1.
My lord, I am for the petitioner, my lord. You have engaged a senior counsel, my lord. He is unable to appear today because due to his ill health, my lord.
What is this IA 1 of 2023?
Vacating stay for stay, my lord.
No, 1 of 2020 vacating the stay filed by HCGP. 1 of 23 ಏನಿದು IA regarding maintainability, who filed this? ಕೊಡಿ IA 1 of 2023.
So next week we will senior counsel will approve the matter.
1 of 23. Three ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ 1 of 23 ಎಲ್ಲಿದೆ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ 17.1 ಅಲ್ಲಿ ಹೌದು ಅದರಲ್ಲಿ 17.1 ಅಲ್ಲಿ
interim order may be.
IA 1 of 2023 is filed by the petitioner seeking early hearing. The same is kept pending till date. Since the matter is being listed, IA 1 of 2023 stands dismissed. 17.1 ali counsel for the petitioner praise time. List on. Next. Yes. 18.
Yes. Serial number 18, Pradeep S. Saukar.
I appear for the petitioners, please, my lord. Lord, on 29/1/26, I filed an application for stay. I appear for the respondent number 2, my lord.
Extend ಮಾಡ್ಬಿಡಿ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ನಲ್ಲಿ
ಇವರು ವಿರುದ್ಧ ಸ್ಟೇ
18 ಅಲ್ವಾ?
ಕಾಮನ್
18
3 4 ಎಷ್ಟು
ಎಸ್ 18
ಕೇಳ್ತಿದ್ದಾರೆ
18 yes
My lord, 18 I appear for the petitioner. But on 29/1/26, I filed an application for stay of proceedings insofar as petitioner number 1 is concerned.
2022 matter you have to address arguments on merits
My lord, I'm
not for stay.
My lord, I'm ready also. Problem is, my lord, accused number 2 is the mother who is about 68 years right now. She's made to go to the police station every 15 days and sign the papers and come. In respect of all other accused matters have been stayed. This honorable court has stayed it insofar as 3 and 4 is concerned.
Now how many matters are pending?
My lord, this one petition and then there's one more petition filed by accused number 1. My lord, in that matter, my lord, this honorable court has stayed the proceedings.
That is pending before which court?
My lord, that is 2025 matter, my lord, writ petition.
Recently
That crossed. Yes, my lord. But that proceedings against accused number 1 is also stayed. It is only, my lord, accused number 2 who is the mother, my lord, the matter is pending.
No.
My lord, I moved this application in that.
Why it kept pending since
Lord,
22?
I have in fact, my lord, filed NOC Wakalat only
Maybe
3 months
that
back,
will
my lord.
be simply because you filed the wakalat. you
Lord,
are
I'm
not
ready and
entitled.
willing to address arguments subject to my learned friend being ready. But my lord, if he's taking time, my lord, I'll press for that IA because she is 68-year-old, my lord.
Only 3 years.
Lord, this order was passed only last month, my lord.
She was old when the petition was filed.
Yes, my lord.
You could have sought for stay.
My lord, it was sought for stay. This honorable court stayed only in respect of the other 2 people. My lord, that is
So
brother-in-law and
obviously for
sister-in-law.
some reason,
My lord, only against brother-in-law and sister-in-law. Now, my lord, in 2025, my lord,
498.
498. Mother-in-law, my lord, she is 68-year-old. Every 15 days, she has to go to the police station and sign the papers and come back.
Why? Under who?
My lord,
who
because,
directed that?
my lord, there was a condition on bail, my lord.
Bail
She
condition.
had bail condition.
Relaxation ಕೇಳಿ.
My lord, relaxation ಕೇಳಿದ್ವಿ because my lord, proceedings are stayed in respect of the entire proceedings are stayed, my lord, ಅದಾಗಿಲ್ಲ.
Cannot be, sir.
My lord, may I
Relaxation-
request, my lord, I am ready to argue, my lord, I am ready to argue today. My lords may hear it and decide it, or my lord, if my learned friend wants time, my lord, this application may kindly be considered. Lord, may I just pass on, my lord, the other court's order?
Why the presence of petitioner is required in the police station?
My lord,
Investigation completed?
no, my
Okay.
lord.
ಇಲ್ಲ.
Stay ಆಗಿದೆ.
ಇಲ್ಲ.
No, my lord, FIR stay ಆಗಿದೆ. FIR stay. The investigation complete. My lord, serious allegation against the present.
No allegations, my lord. In fact, complaint does not have any allegations against the mother.
ಮತ್ತೆ
Then why you failed to get the stay?
My lord, I came on record. When I saw this, my lord, I realized
I
this
am
was not
asking
done.
the petitioner,
Please,
not the
my lord.
advocate who is standing before me.
My lord, the other petitioners got stay, my lord, only against the
Why?
mother.
ಅಷ್ಟೇ ಅದನ್ನೇ
ಅದು
ಕೇಳಿ.
ಯಾಕಂದ್ರೆ my lord, after the order was passed, notice was ordered, my lord, for a long time it was not served. Now, my lord, after service,
Explanation 2022 matter.
Lord, I understand,
No
my lord.
stay was
I am
granted.
before your lordship, my lord.
If you file wakalat and there is
Lord,
urgency.
I am
in the
before
matter.
your lordship, my lord, pursuant to an order passed in the other writ petition, where, my lord, this honorable court has stayed it against accused number 1. My lord, that's the reason I made this application, my lord.
There was one more writ petition which is filed recently in 3348, whereas in that particular, they have mentioned as they are going to settle the matter.
Have you
and
stated?
taken-
Yes,
1 minute.
I am ready and willing to settle.
Have you stated so in your petition that the petitioner is made to appear before the
My
investigation?
lord, I have made it, said so in my application for stay.
In this petition,
My lord, in the application for stay, my lord, on 29/1/2020.
why it is not stated in the petition?
My lord, because, my lord, immediately after registration of FIR, we had filed this petition for stay. My lord, after that, we had to take bail.
ಯಾವುದು connected matter ಇದ್ರೆ ಹೇಳಿ, it will be listed together.
Lord, this application, only some,
Which are those?
my lord, WP number 33244 of
For the coordinate bench,
yes, ma'am.
roster bench.
Yes, my lord.
ಬೇಡ ಅವರು ಅಲ್ಲಿ.
That is the only, my lord, these two are criminal petitions that are pending.
Argue on merits.
My lord, I am
On
ready, my
merits.
lord, my lords, may kindly.
Yes,
My lord, there is one more writ petition which they have recently filed. And
2025.
That is on maintenance, my lord.
No, maintenance, your honor.
Maintenance,
In that, they have stated that they are going to settle the matter in the trial court. But till now, there is no any proposal for that from not only now, from last more than 4-5 years.
That's not true,
They
my
are
lord.
stating the same thing, that they want to settle the matter. The
No,
matter
there is an
not
order
going
for,
to-
there is an order for payment of maintenance.
Yes, yes. May
You
I
are not paying
I have
that?
paid. In fact, what has happened is, my lord, there was an order to pay 40,000 rupees per month. One second, sir.
Wait, sir.
There was an order to pay 40,000 rupees per month maintenance. My lord, that maintenance order, I have challenged it. This honorable court said, I will only give stay if you show your bona fides. Deposit a sum of rupees 10 lakhs, and as and when that amount appropriates, she can withdraw it from the trial court. I have immediately deposited the entire 10 lakh rupees before the trial court, and they've been permitted to withdraw also. I have just shown my
Ordered
bona
more than
fides.
2 years. Not
Entire
even
10
single
lakhs I
pi
have
is paid,
deposited.
my lord. Not even
I am not
single
in
pi-
arrears as of today.
Not even
He
single
says
pi.
he has
See,
deposited rupees 10
recently
lakh.
they have deposited, that's what they say, but they have not furnished
They have
any
to-
copy before
there
the
is-
trial court.
I have,
There is-
we have.
Let me make my.
In fact, my lord, this honorable court has permitted them to withdraw
Wait,
also.
he has something to
Please,
say.
And in that condition is, they want to settle the matter in the trial court. But till now, they have not spoke anything about settlement.
Means to
And not
say-
only that, last 4 years, they are stating the same thing in the trial court.
At least today he is not saying so.
Yes, my lord.
Yes, he is
this
ready
what-
to address the arguments on merits.
Uh,
Can I compel him to compromise the matter?
No, my lord.
I can only compel him to address the arguments on merits. That's
Yes, my
all.
lord. This is recently, last month, they have stated and
regarding-
taken the stay on. That's what I want to bring it before this honorable.
Hey, ಕೊಟ್ಟಿಲ್ಲ sir.
ಇಲ್ಲ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ.
ಅಲ್ಲಿ ಹೇಳಿ, ನನ್ನ ಮುಂದೆ ಹೇಳ್ಬೇಡಿ.
Yes, yes, my lord.
I have not passed any such.
Yes, my lord.
Regarding compromise, my lord, I made that submission, and after that matter hasn't come up before the trial court. That's why
It
we
has come
couldn't make. It
recently,
is posted on
a week
13th.
back it has come, my lord.
ಅಲ್ಲಿ ಕೇಸ್ ಬಂದಾಗ್ಲೇ ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಆಗೋದಲ್ಲ.
My lord,
Overnight it cannot be
I
compromised.
understand, my lord. That's
That
my,
too, the
my
dispute
lord, since
between
the
the
time,
husband and wife.
to be very honest, my lord, without, my lord, any remarks, since the time I have come on record, my lord, my only endeavor is to
Why
make
don't
sure
you
that-
make an effort to compromise the matter?
My lord, I want to make an
It is
effort.
between the husband and wife.
My lord, it is the intention of the husband to make, my lord,
Then,
try and settle it.
give a proposal.
Yes, my lord.
Where is the
We're
proposal?
waiting for the matter to come up on 13th, my lord.
Why it is to be listed, sir?
My lord,
You
because-
know that the matter is pending.
Yes, my lord.
There
It-
must be conciliation.
Yes, my lord.
Why-
In that matter
for-
only, my lord.
For conciliation, why the matter is to be listed before the trial court?
My lord, for me to communicate to the other side, my lord, I thought, my lord, both the parties
No,
would
no,
be
no,
present
no.
on
Give
that.
give the proposal now.
My lord, I'm ready and willing, my lord. I can give him proposal right now, my lord.
Give the proposal.
My lord, there are 3 cases pending.
Give it to him, not to me.
My lord, I'll give it to him, my lord.
I'm
I'll
not
speak.
here to
My lord,
conciliate.
I'm glad my learned friend is come here, my lord. I'll speak to him and try to give a proposal and
You
try
should
to.
take advantage of that.
Absolutely, my lord. This matter, my lord, is coming up for the first time, my lord, since I've come up. That's the only reason.
See,
I will
if-
speak to my learned friend right now, my lord, and try to.
See, if it were to be the intention of respondent wife to pressurize you, to harass you, he would not have made such submission.
My lord,
Luckily, he has
that's the-
made the
my lord,
submission
that's the problem,
that there
my
is a
lord.
proposal.
The records would
Why
indicate
don't you
otherwise.
give the proposal?
My lord, in
These
fact,
are the terms I am ready
lord,
to.
yes, my lord, absolutely.
My lord, the mother,
Lord,
she has given
I'm
that
glad,
much
my lord, your
torture, your
lordships
honor. Still, in spite of
said
that,
that.
mother has given.
So don't go back.
Yes.
He will give
I
some
will give,
proposal.
my lord, in fact, I have
Consider
instructions,
that.
my lord. I will speak to my learned friend immediately and give a proposal. And my lord, may I endeavor to, my lord, settle this matter as soon as I can.
Sir, for a moment, both of you should forget that you are the advocates who are representing.
Absolutely, my lord.
You should facilitate, you should assist them.
Absolutely, my lord. That
Settling
is
the
my
dispute.
endeavor, my lord. That is my endeavor. I will try to
Right.
do that.
Don't act as an advocate.
Absolutely, my lord. I will speak to my learned friend immediately, my lord.
There is no such big fight between the husband and wife.
There is no big fights
solely
at all,
because
my
of
lord.
the mother-in-law.
Making allegations against one another will not result in compromising the matter.
In fact, my lord,
leaving
if
the
I may-
merits, we have spoke. Even we went to their office, your honor. Earlier advocate who was there. We have gone there, discussed for settlement.
Both of you can sit together here.
No, we have spoke. Now,
The difficulty.
but there is no outcome. That's the major thing, my lord.
So ನಿಮ್ಮ effort it is not sufficient ಅಂತ.
ಅಲ್ಲ ನಾವು ಹಾಕಿದೀವಿ ಅವ್ರ ಕಡೆಯಿಂದ there is no any
ಅವ್ರಿಗೆ
further
ಕೇಳಿ, ಅವರು
communication.
My lord, I will endeavor, my lord. I'll speak to my learned friend and try to make sure that it is. I will speak to him
These are the
immediately.
cases where the
In fact, ಇದ್ರಲ್ಲೂ ಕೂಡ.
family members are involved.
Yes, my lord.
They have
Mother,
taken-
sister-in-law, brother-in-law, my lord, all those people are involved in this. In fact, ಏನಾಗಿತ್ತು 2019 she left the matrimonial house.
Now you know the facts of the case.
Please,
Give a proposal to him.
please.
Don't give an unreasonable
No,
proposal.
my lord, I'll be very. I'll in fact give a very reasonable
Give
proposal.
that
my lord.
proposal. Let him communicate it to his client, and both of you come back. If the compromise does not materialize, you argue on the merits.
Please, please. I'll do it.
Yes, my lord. Yes.
Lord,
Lord,
counsel
until
for the
then, my lord,
petitioner,
for mother, may I request?
Respondent number 2.
It may be posted after a week.
Submit that there may be chances of settlement between the parties. And if the proposal for settlement fails, if the effort for settlement fails, they will address the arguments on merits. In the meantime, learned counsel for the petitioner submits that the petitioner, being accused number 2, is the mother-in-law of respondent number 2, and she was required to attend the police station once in fortnight, which is causing hardship to her. It is stated that in a connected matter, the further proceedings is stayed. Under such circumstances, the petitioner is not required to appear before the investigating officer once in 15 days.
My lord, if
As-
stay is
as-
granted, they will not approach us. That's
Huh?
what it is. Even the case will not
Lord,
move,
I will
nor
talk
the.
to my learned friend
This is
immediately.
what
my
it is
lord.
here.
Sir,
This is
ನಾನೇ
what it is,
ಹೇಳ್ತಾ
my
ಇದ್ದೀನಿ,
lord.
I will speak to you.
However,
This is happening from last 4-5 years.
with the investigating officer during investigation, if undertaken by the investigating officer. Yes, list on. Yes, she need not have to appear before the investigating officer
Until
once in
further,
15,
until
but she is required to cooperate with the investigating officer in the matter
Absolutely.
of investigation.
Absolutely.
Yes. ಯಾವಾಗ ನೋಡಿ. Give the proposal. You talk,
Yes, ma'am.
both of you talk to each other.
Immediately I will speak.
Yes. Next.
18th February.
18th February.
18th ಇಲ್ಲ ಆಗಲ್ಲ. ಅವರಿಗೆ ಟೈಮ್ ಬೇಕಲ್ಲ ಅಲ್ಲಿ ಇನ್ನೂ ಅಲ್ಲ.
No, we will try. No, let it not go for further date, my lord. I will try to close it before.
And that's what.
ಸರ್ ನಾ ಸಿಟ್ಟಿಂಗ್ ಇರಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಅದೇ ದಿವಸ
24th or 25th, may I request, ma'am?
24th.
26th.
Huh?
26th.
26th ಆಗಲ್ಲ. Either 24th or in the second week of
24th, my lord.
March.
24th, my lord, I want to try to close it in this
24th.
month.
Serial number 19.
Grateful.
Anumesh, HN.
24th. My lord, I am. My lord, in this matter, I am producing the copy of the death note along with the test report. My lord.
One minute. The petitioner is accused number 3.
Yes, my lord.
It is alleged that she was having illicit relationship with accused number 1.
Yes, my lord.
A2 is the sister. A1 is the husband. Death by hanging. She has left behind a death note. Kudi.
Copy of the death note along with the test report. My lord.
Yes.
My lord, the offense alleged under section 300.
ಗೊತ್ತಾಯ್ತಪ್ಪ. Death note ಇದೆ. There is reference to you, the petitioner, as the root cause for her death.
My lord, the only allegation against her is the A1 is having a illicit relationship, my lord.
And the death note runs into several pages.
Yes, my lord.
There is reference to your name. Rupa, ನನ್ನ ಸಾವಿಗೆ ನಾಗೇಂದ್ರ ನರಸಿಂಹ ಮತ್ತು ಅವಳ ರೂಪನೇ ಕಾರಣ.
Yes, my lord. It may be written in the death note, my lord. My name may be reflecting in the death note. But the reason, my lord, there is nowhere, there is no specific allegation
That
or
is for trial court
my lord,
to consider.
there is no instigation or specific allegation against me, my lord.
No,
Only,
that cannot be.
my lord.
It is a matter for trial.
My lord, 498 does not attract the against me, my lord. 498 only specifically states that only husband and relative, my lord.
506.
And moreover, my lord, I'm relying on certain judgments, my lord. It is covered by the judgment, my lord.
My lord, in first judgment, my lord, page number 2, my lord, para 9.
How many judgments are there?
There are around 4 to 5 4 judgments, my lord.
Where is the index? Where is the index?
I sincerely apologize, my lord.
I apologize. Matte.
I will file the.
You should know, sir, how to produce these citations before the court.
Please.
Why are you relying on this?
My lord, the cases are all on same set of facts, my lord.
Hmm.
One or the other way, it's connected with the illicit relationship and 306 and 498, my lord.
Yes.
In first judgment, my lord.
What is the ratio laid down? What is the principle of law laid down by the apex court?
My lord, the mere having illicit relationship.
Para number.
My lord, in first judgment, my lord, para number 9, my lord, page number 2, my lord.
Page number 2 now.
Yes, my lord. First judgment, my lord. Para number 9, my lord. May I read, my lord?
That is on facts of the case, sir.
My lord, in this case also the 498 was
498A, yes.
Yes, he has been invoked.
Yes,
He has been invoked, my lord.
that is there. 506. 306.
6 my lord, next judgment, my lord. Page number 13, my lord. Second judgment, para 23, my lord.
Page number
13, my lord. Para 23, my lord. The Supreme Court clearly observed, my lord, may I read, my lord? We are of the view that mere fact that the husband has developed some intimacy with another during the subsistence of marriage and failed to do discharge his marital obligations as such would not amount to criminality, but it must be of nature as is likely to drive this.
That is again 498A.
Supposed to it's include 306 also, my lord. Supposed to commit suicide to fall within the explanation of to section 498A IPC harassment, of course, need not be in the form of physical assault, and even mental harassment also would come within the purview.
That is all regarding 498A.
My lord, in this case also there was an invocation of the section 306, my lord. The Supreme Court clearly observed that mere intimacy with another woman does not constitute a 306, my lord. The para 27 also, my lord.
No, it is not. She has left behind a death note, sir, making specific allegations.
That has been discussed.
Such a death note was there in those cases.
Yes, my lord. In the earlier next judgments, my lord, there was a death note also, my lord.
Yenanta?
My lord, in para 27, my lord, section 306 refers to abatement of suicide. It says that if any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment for a term which may extend to 10 years and shall also liable to fine. The action for committing suicide is also on account of mental disturbance caused by mental and physical cruelty to constitute an offence under section 306. The prosecution has to establish that a person has committed suicide and the suicide was abated by the accused. Now here there is no ingredients showing that the petitioner has abated or instigated or aided or nothing else, my lord.
Have you gone through the death note?
Yes, my lord. Only in last sentence they have included my name, my lord.
No. In the body of the death note, there is no reference.
No, there is.
Hmm? Yes.
My lord, only allegation, my lord, illicit, having a illicit relationship with the A3, my lord. It's purely our presumption, my lord. There is no any corroborating evidence in the entire charge sheet, my lord. To show
Have my question, you have to answer my question.
Yes,
Have
ma'am.
you gone through the death note?
my lord, just now we were just my lord.
Without going through the death note, how can you say that there are no materials? And you are citing, you are relying on 4 judgments. For what purpose? Is it the way of addressing the argument?
My lord, I will
You
go
don't
through.
know the facts,
I will
you
go-
don't know the contents of the death note, and you are arguing the matter.
I will go through the death note, my lord.
Last time after hearing you, it is adjourned to go through the death note. Till date, you have not gone through the.
My lord, death note has been served now, my lord.
After serving, have you gone through it?
Just now it has been served.
Why are you addressing the argument? Why you are wasting the time of the court? And you are relying on so many judgments.
I prefer short accommodation, but I will go through the judgment, whatever this suicide note it is, and I will argue, address the argument on the.
Pass over. Last year, 19. Pass over.
Passed over matter, serial number 3. Sudhindra BS, N. Jagdish Baliga.
The office has raised objection saying that the second respondent is not a party. Vakalata, on that ground,
Party ಇಲ್ದಿದ್ಮೇಲೆ ನೀವು how can you say
ಅಲ್ಲ
that
ಅವರು
respondent
ಕಾಂಪ್ರಮೈಸ್
number 2?
ಆದದ್ರಿಂದ
No, sir. If he or she is a party, you can refer it respondent number 2.
ಹೌದು
Respondent number 2
ಅಲ್ಲ
ಅಂದ್ಮೇಲೆ party
ಕಂಪ್ಲೇನೆಂಟ್
ಅಲ್ಲ.
ಅಂತ ಬರಿಬೇಕಿತ್ತು ಅವರು ಬಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಹೌದು ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಕರೆಕ್ಟ್ ಕಂಪ್ಲೇನೆಂಟ್
ನಾವು ಹೇಳ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ.
Then rightly the objection is raised.
ಪ್ಲೀಸ್ ವಕಾಲತ್ತಲ್ಲಿ ಸರಿ ಮಾಡಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಮಾಡಿ.
ಈ ಬೇಸಿಕ್ಸ್ ಎಲ್ಲ ಇಲ್ಲಿ ಏನೋ ಅವಸ್ಥೆನ.
Now compounding application is filed.
Unless he comply with the
ಅಲ್ಲ
office
ಮಾಡಿ
objections,
complaint.
I will not take up.
ಪ್ಲೀಸ್
ಎಷ್ಟೊತ್ತು ಬೇಕು ಸರ್ ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಕ್ಕೆ?
ವಕಾಲತ್ ಕೊಟ್ರೆ ಮಾಡ್ತಾರೆ.
ಕೊಡ್ಲಿಲ್ವ ಅವರು ಕೇಳಿದ್ರೆ?
ಕೊಟ್ಟಿದ್ರು
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನಿಮಗೆ?
ಅದೇ ಅವರಿಗೂ
ಏನ ಪಾರ್ಟೀಸ್ ಬಂದಿದ್ದಾರೆ. Why they should wait?
Please,
At whose fault? They think that the court is taking time.
Yes.
ಅವಕಾಲತ್ ಹಾಕಿದವ್ರಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ, ಕಣ್ ಬಿಡ್ತಾ ಇದ್ದಾರೆ ಅವ್ರು. ಅಂಡ್ ಹಿ ಇಸ್ ಅನ್ ಅಡ್ವೊಕೇಟ್.
ಮಾಡಿಸ್ತೀನಿ ಸರ್.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ ಮಾಡಿದ್ಮೇಲೆ ಅದನ್ನ ಕಂಪ್ಲೈ ಹೇಗ್ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಿಲ್ವಾ? ಇಟ್ ವಿಲ್ ಟೇಕ್ 1 minute.
ಸರಿ ಮಾಡಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ
ಮಾಡ್ತೀನಿ.
ಏನ್ ಮಾಡ್ತೀರಿ?
ಅದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸ್ಲಾಶ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಮಾಡಿದ್ದೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರ ಅವರು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಯಾಕೆ ಬರೀತೀರಿ?
ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಆರ್ಡರ್
ಸ್ಲಾಶ್ ಎಲ್ಲಿ ಬರುತ್ತಲ್ಲ ಇವಾಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲದೆ ಇದ್ದಾಗ? ನೋಡಿ, ಸ್ಟಿಲ್ he do not know.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
I will assist.
ಒಂದ್ಸಲ ಪಾಸ್ ಓವರ್ ಆದ್ಮೇಲೆ ಆದ್ರೂ ಬೇಕಲ್ಲ ಸರ್?
ವಿತ್ ಪರ್ಮಿಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್.
Then why it was passed over? Am I not permitted you to comply with?
Please,
then
permitted.
ನೀವು ಇಲ್ಲೇ ಇರ್ತೀರಿ. ವಾಟ್ ಅಬೌಟ್ ದಿ ಪಾರ್ಟೀಸ್? ಕೊಡ್ರಿ ಅವ್ರಿಗೆ, ಅದೇನ್ ಮಾಡ್ತಾರೆ ಅಂತ ನೋಡ್ಕೊಳ್ಳಿ. ಅವ್ರು ಇನ್ನೇನ ಬರ್ದರು, ಅವರಿಗೆ ಬಿಟ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾರ.
ಬೈಕ್ನಲ್ಲಿ ಹಿರಿಯಮ್ಮ ಹೋಗ್ಬಿಡಿ.
ಎಲ್ಲಿದೆ 320 ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ?
ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ?
ಯಾರು PW1?
ಬನ್ನಿ ಮುಂದೆ ಬನ್ನಿ, ಅಲ್ಲಿರಿ.
ಏನು ಹೆಸರು ನಿಮ್ದು?
ಎಲ್ ಶ್ರೀನಿವಾಸ್.
ಹಾ?
ಎಲ್ ಶ್ರೀನಿವಾಸ್.
ನಿಮ್ಗೆ ಹಣ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಮೇಡಮ್ ಹಾಸ್ಪಿಟಲ್ ಖರ್ಚಾಗಿ ಹೊರಗಡೆ.
ಹಾ?
ಹಾಸ್ಪಿಟಲ್ ಖರ್ಚಾಗಿ ಹೊರಗಿದ್ದಾರೆ.
ಅಲ್ಲ ರೀ, ನಿಮ್ಗೆ ಮತ್ತೆ ಬೇರೆ ಏನಾದ್ರು ಹಣ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹಾಸ್ಪಿಟಲ್ ಖರ್ಚಿಗೆ 75,000.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
75,000.
ಹಾ?
75,000.
ಅಷ್ಟೇನಾ? ಮತ್ತೇನ್ ಬರ್ಬೇಕಾಗಿಲ್ವಾ? ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದಾ? ಅವರ ಅಕ್ವಿಟ್ ಅವರನ್ನ ಬಿಡುಗಡೆ ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು.
ಎಸ್. Then at counsel for the appellant filed application under section 321 of CRPC seeking permission to compound the offence. Respondent, the complainant respondent beda, the complainant L. Srinivas is present before the court and he is identified by his counsel. The complainant has sworn an affidavit which reads as under affidavit complainant L. Srinivas admit the contents of the affidavit and submits that he had received rupees 75,000 towards hospital charges, and that he has no objection to allow the appeal and to acquit the accused, as the dispute is amicably settled and they are residing with cordial terms. Next part. The appellants being accused numbers 1, 2. They are accused numbers 1, 2.
1 to 4.
In these appeals being accused numbers 1 to 4 were convicted for the offence punishable under section 353, 324, 307, read with 34 of IPC. They have preferred these appeals before this court, impugning the judgment of conviction and order of sentence. This court today, judgment dated 12/6/2025, dismissed the appeals and confirmed the judgment of conviction and order of sentence. Being aggrieved by the same, the appellants have approached the apex court, which remanded the matter to this court to hear afresh In the meantime, the dispute between the parties is settled amicably and the application seeking permission to compound the offence is filed. Next paragraph. On facts of the case, it is found that the appellants and the complainant are the residents of same village and they are residing and the dispute between them is settled amicably and they are residing with cordial terms. Compensation of ₹75,000 is paid to the informant PW1 towards hospital charges. Considering these facts and circumstances, and also in view of the fact that the informant PW1 has no objection to allow the appeal, I deem it appropriate to allow the application and accord permission to compound the offence. Accordingly, IA 1 of 2026 filed under section 320 1 of CRPC is allowed. These are permitted to compound the offence. Next, into consideration the affidavit sworn by the informant PW1. The appeal is allowed. Judgment and decree dated 12/6/2025. Judgment of conviction and order of sentence. What is the date of judgment by the trial court?
5/8/2013.
5/8/2013.
13.
Is set aside. Appellants accused numbers 1 to 4 are acquitted for the offence punishable under sections 353.
323. 323.
ಇಲ್ಲಿ 53 ಅಂತ
ಅಲ್ಲ
ಹಾಕಿದ್ದಾರೆ.
ಸಾರಿ ಅದು ಕೊನೆಯಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆ.
ಎಲ್ಲದೂ ಸಾರಿನೇ.
323
323 and 324.
24 307.
323 324 307. Make that correction.
Please, I
ಮೇಲ್ಗಡೆ 353 ಎಂದಿದ್ದೀನಿ ಅದನ್ನು 323 ಅಂತ ಮಾಡಿ. Are set aside, are acquitted for the offence punishable under yes, appeal is allowed with the law. Judgment and decree date, a judgment of conviction and order of sentence dated so and so, passed by so and so, is set aside. Consequently, appellants accused numbers 1 to 4 are acquitted for the aforesaid offences. Bail bonds executed by the appellants and their sureties stand discharged. appellants who are said to be in judicial custody are ordered to be released forthwith if they are not required in any other cases.
Fine amount.
Fine amount deposited, if any, is ordered to be refunded to the appellants. Hmm? ಎಲ್ ಶ್ರೀನಿವಾಸ ಅವರು ಪಾರ್ಟಿ ಇಲ್ಲ ಕರೆಕ್ಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲಿ ಬೇಡ್ರಿ ವಕಾಲತ್ನಲ್ಲಿ ನೀವು ಹಾಗೆ ಹಾಂ ಅಷ್ಟೇ ಕಾಂಪ್ಲಿಮೆಂಟ್ ಅಷ್ಟೇ ಎಸ್ yes he has to sign the order sheet and you have to identify him.
Please, my lord.
Intimation of jailige intimation.
Issue intimation accordingly to the jail authority.
Much of this.
Yes. Next.
Serial number 5, Karumbaya TA.
I'm filing memo along with the copy of the acknowledgement for service of notice to R2, my lordship.
Learned HCGP filed a memo reporting service of notice to respondent number 2. R2 called out absent. Yes.
Whereas the petitioners are accused number 1 to 4.
You are arguing on merits. ಅಷ್ಟೇ ತಾನೆ?
Oh.
ಅದು ಬೇಡ ಬಿಟ್ಬಿಡಿ. Yes, who is the petitioner?
Petitioners are accused number 1 to 4, my lord. Accused number 2 is the father.
Four accused?
Pardon me?
In all, only 4 accused are
Yes,
there?
yes, only 4. Accused number 2 is the father and accused number 4 is the mother of accused number 1. And accused number 2 is the 3 is the brother of accused number 1, sir.
What are the offences?
According to in the FIR, the offences were charged for 417, 420 and 506 read with section 34, 417, 420 and 506 of read with section 34, sir. But while filing charge sheet, 417, 420, 506, 494, 498A read with section 34.
No, 417, 420,
506, 494, 498A and 34. The second respondent has filed a private complaint. You will last kindly see page number 11.
Private complaint PCR number?
PCR number 15 of 2012. Sir.
Against A 1 to 4.
Yes. You will also kindly see page number 11. Annexure A is the complaint, Sami.
No, that was referred for investigation.
Yes. And the crime number 26 of 2012 was registered.
Of which
by the
police
first
station?
respondent police.
Which police station?
Sargura. Aldur, Sami. Aldur police station in Chikmagalur district.
Alduru.
Aldur.
Yes.
Then at the time
Where
of
is the charge sheet?
charge sheet, at the time of crime, my lord, I approached this honorable court for quashing. You will also kindly see the order passed.
ಅವ್ರು ಯಾರು?
Is accused number 2, Sami.
ಕೂತ್ಕೊಳ್ಳಿ ಅವ್ರು ಯಾಕೆ ನಿಂತ್ಕೊಂತಾರೆ? ಕೂತ್ಕೊಳ್ಳಿ.
You will also kindly see Annexure C at page number 29. That petition was disposed on the ground that the charge sheet was filed.
Page number?
Page number 29. Annexure C. Criminal petition number 3657 of 12.
On merits dispose ಆಗಿದೆ. On merits.
ಹೌದು merit, but on the ground that there was charge sheet was filed. Page number internal page 10 ನಲ್ಲಿ The private complaint filed under section 200 CRPC, which has now culminated into a complaint respondent number 1 police filing the charge sheet against the petitioners. In the said circumstances of the case, merely on the alleged ground of delay, the criminal proceedings initiated by respondent number 2 cannot be set aside. Yes. Now, your last time, kindly see the complaint at page number 11, my lord. Page number 12 is the second paragraph, my lord. May I read, my lord? Page number 12. 11 is the complaint, first page. And page number 12.
Date of marriage?
5/2/2009, 29/5/2009.
29.
29/5/2009.
This complaint was filed?
Yeah, filed on 25/1/2012. 25/1/2012.
Yes.
Now, second paragraph, my lord. It is submitted that on 29/5/2009, the accused persons, along with one Sri H.K. Payanna, introduced themselves to the family of the complainant, and they offered to solemnize the marriage of the complainant with accused number 1 on the same day. And all of a sudden, on the same day, the accused persons took the complainant with them to Sri Ganapati temple at Mudigere town and exchanged the garland and concluded the above said ceremony as marriage. Actually, essential requirements of marriage like Saptapadi and sacred life fire and Mangalya Dharana and such other traditional ceremonies were not taken place to constitute the valid marriage as per the Hindu Marriage Act and traditions and subsequently the accused person took the complainant with them to their house. So according to the complainant, there was no valid marriage.
Yes.
Now we'll also make kindly see the next annexure B. It's page number 18, my lord.
No, what are the further allegations?
Further allegations. The allegation that he has suppressed the earlier existence of the earlier marriage. And accused number 1 has been and was the accused number 1 was abusing about her character. According to her, I have suppressed my earlier marriage, accused number 1.
Where is the charge sheet?
Charge sheet is at page number 44, madam. Oh, sorry, 40. Annexure D is at page number 40.
Come to 42,
40, yes.
column number 17.
ಕಲಂ ದಿನಾಂಕ 29/5/2012ರಂದು ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಒಬ್ಬೂರು ಹೋಬಳಿ ಆಲೂರು ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನಲ್ಲಿ ಚಿಕ್ಕಳ್ಳ ಗ್ರಾಮದ ವಾಸಿ ಸಾಕ್ಷಿ ನಂಬರ್ 1ರನ್ನು ಶ್ರೀ ಪಾಯಣ್ಣ ಎಂಬುವರು ಮಧ್ಯಸ್ಥಿಕೆಯಲ್ಲಿ A1 ಮೂಡಿಗೆರೆ ಗಣಪತಿ ದೇವಸ್ಥಾನದಲ್ಲಿ ಯಾವುದೇ ಹಿಂದೂ ಸಂಪ್ರದಾಯ ವಿಧಿವಿಧಾನವಿಲ್ಲದೆ ಕೇವಲ ಆಹಾರ ಬದಲಾವಣೆಯ ಮುಖಾಂತರ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, 3 ಮತ್ತು 4ರವರ ಸಮ್ಮುಖದಲ್ಲಿ ಮದುವೆಯಾಗಿದ್ದು, ನಂತರ A1ರವರು ಸಾಕ್ಷಿ 1ರನ್ನು ತನ್ನ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು, ನಂತರ ದಿನಗಳಲ್ಲಿ A1 ಮತ್ತು ಸಾಕ್ಷಿ A1ರವರಿಗೆ ನೀನು ನನ್ನ ಹೆಂಡತಿಯಲ್ಲ ಎಂದು ನಿರ್ಲಕ್ಷಿಸಲು ಪ್ರಾರಂಭಿಸಿದಲ್ಲದೆ, ಸಾಕ್ಷಿ 1ರವರೊಂದಿಗೆ ಯಾವುದೇ ರೀತಿಯ ವೈವಾಹಿಕ ಸಂಬಂಧವನ್ನು ಇರಿಸಿಕೊಡುವುದಿಲ್ಲವೇ. ನಂತರ A1 ಸಾಕ್ಷಿ 1ರವರ ನಡತೆಯ ಬಗ್ಗೆ ಸಂಶಯ ವ್ಯಕ್ತಪಡಿಸಿ ಆರೋಪಿತರೆಲ್ಲರೂ ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಹಿಂಸೆಯನ್ನು ಕಿರುಕುಳ ನೀಡಿರುತ್ತಾರೆ. ನಂತರ ದಿನಗಳಲ್ಲಿ A1 ಬಲವಂತವಾಗಿ ಸಾಕ್ಷಿ 1ರವರನ್ನು ಮನೆಯಿಂದ ಹೊರ ದಬ್ಬಿರುತ್ತಾರೆ. ನಂತರ ಸಾಕ್ಷಿ 1ರವರಿಗೆ A1 ಸಾಕ್ಷಿ 1ರವರಲ್ಲದೆ ಸಾಕ್ಷಿ 8 ಮತ್ತು ಮತ್ತೊಬ್ಬರನ್ನು ಮದುವೆಯಾದ ವಿಚಾರ ತಿಳಿದು ಬಂದಿದ್ದು, ಸಾಕ್ಷಿ 8ರವರು ಹಾಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ A1ರವರ ವಿರುದ್ಧ ಕೇಸುಗಳನ್ನು ದಾಖಲಿಸಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಸಾಕ್ಷಿ 1ರವರು ಮತ್ತು ಅವರ ಕುಟುಂಬದವರು ಪ್ರಶ್ನಿಸುವಾಗ ಆರೋಪಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಆಕೆಯ ಕುಟುಂಬದವರಿಗೆ ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. A2 ಮತ್ತು A3, A4ರವರು A1ರವರ ಸಹೋದರ, ತಂದೆ ಹಾಗೂ ತಾಯಿಯಾಗಿದ್ದು, ಎಲ್ಲರೂ ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಸಾಕ್ಷಿಯವರಿಗೆ ಮೋಸ ಮಾಡುವ ಸಲುವಾಗಿ A1 ತಾನು ಈ ಹಿಂದೆ 2 ಹೆಂಗಸರನ್ನು ಮದುವೆಯಾದ ವಿಚಾರವನ್ನು ಮುಚ್ಚಿಟ್ಟು ಯಾವುದೇ ವಿಚ್ಛೇದನೆ ಪಡೆಯದೆ ಮದುವೆಯಾಗಿರುವುದು ತನಿಖೆಯಿಂದ ಸಾಬೀತು ಆಗಿರುತ್ತದೆ. Now your lordship may kindly see annexure B, my lord.
Allegations are serious in nature.
No, your lordship may kindly see, appreciate, my lord. The fundamental thing, as per the complaint, there was no marriage. And your lordship may kindly appreciate the fact on 25/9/2009, the accused number 1 to 4 goes to the house of the second respondent,
Yes.
and in presence of a mediator, and on the same day without any enquiry there will be any marriage, my lord. That is the
Believed you?
no, that is
Believed you? Why there was exchange of garland in the temple? What does it mean?
no, that will not conclude the
Have you
marriage.
filed a suit declaration that it was not a marriage?
No, because she has filed the petition for
What happened to that?
under section 12, it is allowed.
Which one?
Annexure B, your lordship. She has filed the petition under section 12 in the year 2011, much prior to filing of this complaint. This is of 2011
Under section
and 12
of Hindu marriage.
Hindu Marriage Act.
That was allowed?
Allowed.
Ellide.
Your annexure B, your lordship.
Page number.
Page number is 18. The operative portion is at page number 25. my lord. This petition is allowed. The marriage solemnized on 29/5/2009 is hereby declared as null and void. Page number 25, ink page, my lord. Internal page 8, my lord. And this is prior to filing of this private complaint, my lord. This is originally MC number 129 of 2011 and subsequently transferred to the Principal Judge Family Court after the constitution of the Family Court at Chikmagalur, and it is renumbered as MC number 51 of 13. Whereas this complaint is filed in the year 2012, 25/1/2012.
You have not challenged this.
This order, insofar as the portion of consummation of the marriage is concerned, I filed appeal before this honorable court. But this honorable court dismissed my MFA on the ground that, my lord, when the marriage is held to be null and void, that observation will not come in the way of the accused number one. Regarding solemnization, that because she herself in the complaint has stated that there was no solemnization, there was no relationship of
What
marriage.
is your contention?
No, in the complaint she has said.
What is your contention?
My contention, there was no marriage at all.
Then why you took her to your house? ಸುಮ್ನೆ ಯಾರೋ ದಾರಿಲಿ ಹೋಗೋರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರಾ?
That is one part, my lord, but any female without enquiry about the...
ಸರ್ ಆಯ್ತು ಸರ್, ಅವಳನ್ನ ಬಿಟ್ಬಿಡಿ. ಅದಕ್ಕೆ ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, why you took her to your house? If there was no marriage, if she was not your wife, why you took her?
And even in the petition under section 12, the same averments are made in the petition, my lord.
The MC.
For how many days she stayed with your house?
No, according to me, she has not stayed in the
No,
house.
according to the complainant.
Complainant, for a few months, she has not stated how many days.
ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Para number 3 ಅಲ್ಲಿ, end of the second para, in the Marriage Act tradition, the accused persons took the complainant with them to their home. Further, it is submitted that from the beginning, the accused number one was avoiding.
ಎಲ್ಲ ಆಯ್ತು ಸರ್.
ಅದೇ ಡೇಟ್ ಏನು ಅವಲಾಂಗ್ ಅಂತ ಹೇಳೋದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಸರ್.
Complainant was forced to leave the accused number one.
ಯಾವಾಗ ಏನು ಹೇಳಿಲ್ಲ. Accused number one was forced to leave the house ಅಂತ ಹೇಳ್ತಾರೆ.
And immediately she filed MC.
Yes. MC was filed in the year 2011.
Yes, what do you say?
My lordship, in the MC case also, the case between the first wife is pending. All the reasons has been narrated, my lordship. With respect to cheating, my lordship, there is a clear allegation in the charge sheet also, my lordship.
When she herself had filed the suit to declare her marriage with accused number one as null and void.
Yes, my lordship.
She should have sought for compensation.
Yes, my lordship.
ಅದೇನೋ ಕೇಳಿಲ್ಲ. She was satisfied with the declaration that the marriage is null and void. She is aged 27 years.
Please, my lordship.
How can you say that she is so innocent? Why she had gone to his house? ಅವತ್ತೇ ಬಂದ್ರಂತೆ, ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಕೂಡಲೇ ಆಹಾರ ಬದಲು ಮಾಡ್ಕೊಂಡು ಅವ್ರ ಮನೆಗೆ ಹೋಗ್ಬಿಟ್ಟು. What does it mean? Can it be said that it is a cheating? ಚೀಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನಿರ್ಬೇಕು? She is party to that.
Yes, my lordship.
Then she is a major.
Major only.
498 cannot be invoked.
Please, my lordship, it cannot be invoked.
Then
Invoke, my lordship.
what remains then? ಯಾವುದು charge sheet 417, 420, 506, 594, 590, 498A.
Bigamy. If marriage.
ಯಾವುದು ಬರಲ್ಲ. Unfortunately, she herself filed the suit.
Please, my lordship. For nullity of the marriage.
Then she could have sought for compensation with the declaration. Maintenance ಏನು ಕೇಳಿದ್ರೆ ಇಲ್ಲ. She stayed for 2 years there.
Yes, my lordship.
And the complaint was came to be filed in the year 2012.
In the year 2012, before that only she has filed for nullity of the marriage.
That was there. If a complaint was filed first, thereafter file a suit for so and so, I can understand.
Please, my lordship.
Here it is otherwise.
Please, my lordship.
The petitioners being accused numbers 1 to 4.
CC number 312.
In CC number 312 of 2019, on the file of the learned civil judge and JMFC Chikmagalur, bracket nulli, crime number 26 of 2012 of Aldur police station, bracket complete, registered for the offence punishable under section 417, 420, 506, 494, 498A, read with 34 of IPC. Are seeking to quash the criminal proceedings initiated against them. But 594 will apply.
Sorry?
494 will apply.
No, you will have to kindly see the judgment of this honorable court, my lord. 494, saying that the complaint is not supported by the affidavit. Therefore, the learned magistrate ought not have referred the matter under section 156.
That is all curable defects.
ಅದಕ್ಕೆ ಇದರಲ್ಲಿ 494 ಬರೋದಿಲ್ಲ ಅಂತ ಕಲಬುರ್ಗಿ ಬೆಂಚಲ್ಲಿ 494 ಬಗ್ಗೆನೇ ಹೇಳಿದ್ದಾರೆ.
ಯಾಕೆ ಬರಲ್ಲ ಅಂತ?
Because since there was no marriage.
Marriage ಇದೆ, it is declared as null and void, and your appeal MFA was dismissed. Marriage ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. Marriage ಆಗಿದೆ. It was during the subsistence of earlier marriage with one Veena.
That was
very specific finding.
It was there, and I cannot dispute that.
Then, as per the judgment, you married during the subsistence, and even it is stated, you violated the interim order not to marry.
No, if it was the marriage, my lord, then yes, my lord. If there was marriage.
417, 420, 506, 498
kindly see,
may not arise.
There will not be any relations. A Supreme Court judgment reported in 2025 2 SCC 587, where the Honorable Supreme Court has held that when there is violation of section 7, then there is no marriage at all. If the
violation of section 7,
and if the marriage is not performed in accordance with the customary.
ಅದೆಲ್ಲ ಬರಲ್ಲ. ಎಲ್ಲಿದೆ?
Yes.
ಬಿಡಿ, ಅವೆಲ್ಲ ತಗೋಬೇಡಿ. 2 ವರ್ಷ ಸುಮ್ನೆ ಇದ್ರೇನೋ ಜೊತೆಗೆ.
ಹಂಗಲ್ಲ
ಅವೆಲ್ಲ ಕತೆ ಹೇಳ್ಬೇಡಿ ಇಲ್ಲಿ. ಯಾವ್ದು
Sections, second paragraph.
ಯಾವ್ದು 2025 2
587, Dolly Ronnie.
87 ಏನು
Meaning marriage.
which paragraph?
B, head note B, Millard.
ಇದರಲ್ಲಿ ಯಾವ್ದು offense ಇದ್ದಿದ್ದು?
ಇದರಲ್ಲೂ regarding the marriage, Swami.
ಇದರಲ್ಲಿ 494 ಇಲ್ಲ.
But
498A, 420, 506, 509, read with 34.
oh,
ಎಲ್ಲಿದೆ 494?
490 single judge ಇದ್ದು judgment ಅಲ್ಲಿ.
So ಇದಲ್ಲ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಬರೀ section 7 ಬಗ್ಗೆ. ಹಾಗಾದ್ರೆ then if it is a case, my lord, it is only against accused number 1.
ಅದಷ್ಟೇ. You cannot escape, sir. You cannot escape. Of course, others, father, mother, ಅವರೆಲ್ಲ ಬಿಡಿ. But not accused number 1. I will allow the petition part in part. ಅಷ್ಟೇ. Let him be answerable. ಇದನ್ನ ಯಾಕೆ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಅದೇ 494 ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅಂತ
ಎಲ್ಲಿದೆ? ಏನಿದೆ? What is the reason of that?
Reference made under section 156(3) itself is bad ಅಂತ ಹೇಳಿ.
156(3) ಎಲ್ಲ ಈಗ ಇಲ್ಲ. ನಿಮ್ದು ಅರ್ಲಿಯರ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಇವಾಗ ಬಂದು 156(3) ಅಂದ್ರೆ you should have taken at the earlier stage. That was not considered by this court.
Yes, at the crime stage.
Yes, ಬರಲ್ಲ.
Please.
So 494 ಬರುತ್ತೆ, ಅದಕ್ಕೆ you are answerable.
Only accused number 1.
Only accused number 1.
Yes.
ಏನಾಯ್ತು? So filed ವಕಾಲತ್ ಅಲ್ಲ, sorry. ಅದಾಯ್ತು. Next. Facts of the case in brief are that respondent number 2 filed the private complaint in PCR 15 of 2012 before the trial court against accused numbers 1 to 4, alleging commission of the offence punishable under section 417, 420, 506, read with section 34 of IPC. The complaint was referred for investigation under section 156(3) of CRPC. The investigating officer registered the FIR in crime number 26 of 2012 of Aldur Police Station, Chikmagalur district. After investigation, charge sheet came to be filed for the offences under section 417, 420, 506, 494, 498A, read with section 34 of IPC. Now the matter is pending in CC number so and so. In the meantime, the petitioners, being accused numbers 1 to 4, are before this court seeking to quash the criminal proceedings initiated against them. Next para. It is noticed that the petitioners have approached this court by filing criminal petition number 3657 of 2012, seeking to quash the criminal proceedings initiated against them during crime stage. The said petition was came to be dismissed with a order dated 9/10/2018. After filing of the charge sheet and then the learned magistrate taking cognizance and registering the criminal case, the petitioners are again before this court. Heard so and so. Use the materials point for consideration. My answer to the above point partly in the affirmative for the following reasons. Respondent number 2 as complainant filed the private complaint alleging that accused number 1 along with accused number 2 to 4 have taken her to a temple and her marriage with accused number 1 was performed by exchange of garland on 25/1/2012, 29/5/2009, 29/5/2009. After marriage with accused number 1, she had been to the house of accused number 1 and started residing with accused number 2 and 4 being father and mother, and accused number 3 being the brother of accused number 1. During this period, she was treated with cruelty. Her fidelity was questioned by accused number 1. It is also her contention that she was cheated by accused number 1 to 4, and she was made to exchange the garland. Therefore, she filed the suit OS number
MC.
129 of MC 129 of 2011. 129 MC
129 of 2011.
MC or OS?
MC.
MC 129 of 2011, seeking declaration that the marriage dated 29/5/2009 is null and void. The said petition came to be renumbered as MC 511 or 51.
51 bar
51 bar
2013.
2013
Family Court,
came on the file of the
Principal Judge, Family
Family Court at
Chikmagalur.
Chikmagaluru. Accused number 1 had not contested the matter, and the suit came to be decreed with a judgment and decree dated 31/10/2013, declaring that the marriage of the complainant with accused number 1 held on 29/5/2009 is null and void. Even though the said judgment was challenged by accused number 1 by preferring a miscellaneous first appeal before this court, the same came to be dismissed. Thus, the decree declaring that the marriage between accused number 1 and the complainant is null and void has reached finality. Next, during the pendency of MC 129 of 2011, the complainant filed the private complaint in PCR number 15 of 2012 against accused numbers 1 to 4, alleging commission of the offence under section 417, 420, 506, read with section 34 of IPC. However, after investigation, charge sheet came to be filed for the offence under section 417, 420, 506, 494, 59, 498A, read with 34 of IPC. Next part. It is noticed that the complainant, respondent number 2, was aged 27 years during 2012 when the private complaint came to be filed. It is pertinent to note that before filing the private complaint in the year 2012, MC 129 of 2011 came to be filed before the family court at Chikmagaluru, seeking declaration that her marriage with accused number 1 is null and void. It is specifically contended that accused number 1 to 4 came to respondent number 2, and on the same day she was taken to a temple at Mudigire and she exchanged garland with accused number 1. However, first off, she also states that after exchange of marriage, she had been to the house of accused number 1. However, she contends that there was no traditional ceremonies that had taken place to constitute a valid marriage, and therefore the said marriage is null and void. Next part. It is also stated that accused number 1 had already contacted a marriage with one Veena, and during the subsistence of such marriage, accused number 1 married the complainant. This court, while dismissing criminal petition 3657 of 2012, observed that there was an interim order operating against accused number 1 not to contact a second marriage during the subsistence of his marriage with Veena, and violating the said interim order that was passed in OS 32 of 2006. Accused number 1 had contacted the marriage with the complainant. These facts are not in serious dispute. Even though the marriage is declared to be null and void, when the fact remains that accused number 1 was already married another lady and there was an interim order not to contact second marriage, comma, the act of accused number 1 prima facie attracts section 494 of IPC, which relates to marrying again during lifetime of a wife, husband or wife. With these undisputed facts of the case, the offense under section 494 of IPC is made out against accused number 1, and therefore he is not entitled for quashing the criminal proceedings for the said offense. Next part. The allegations against the accused for the offense under section 498A cannot be invoked for the simple reason that the marriage between the complainant and accused number 1 is already declared as null and void by a decree passed by the family court on 31/10/2013 on the basis of the suit that was filed, on the basis of a petition filed before the family court during 2011, which was much earlier to filing of the complaint before the trial court. Next part. Regarding the offense under section 417 and 420 of IPC, as I have already stated, the complainant was not a minor, nor she was disabled to take an independent decision. Her specific contention is that she accompanied accused number 1 to 4 to a temple and exchanged the garland on the same day and went and started residing with accused number 1 along with accused number 2 to 4. Under such, the complaint came to be filed only during 2012 after filing a petition seeking declaration that her marriage with accused number 1 is null and void. Under such circumstances, it cannot be said that there was a cheating to invoke section 417 or 420 of IPC. Next, regarding the offense under section 506 of IPC, there is bold allegation regarding giving life threat to her by the accused. On the basis of such bold allegations, the criminal proceedings cannot be initiated or proceeded with. Therefore, I am of the opinion that the offense under section 417, 420, 506, 494, 594, 498A, read with section 34, alleged against accused number 2 to 4 is liable to be quashed. However, accused number 1 is full stop. The offense under section 417, 420, 506, 498A, read with section 34 of IPC against accused number 1 is liable to be quashed. However, petition number 1, accused number 1 is liable to face the trial for the offense under section 494 of IPC, as there are prima facie materials to constitute the offense against him. Accordingly, I answer the above point partly in the affirmative and proceed to pass the following. Petition is allowed in part. Criminal proceedings for the offence under section 417, 420, 506, 598A, read with section 34 of IPC, initiated against petition number 1, accused number 1, is quashed. His petition to his petition for the offence under his petition seeking quashing of the criminal proceedings for the offence punishable under section 494 of IPC is rejected. Next, criminal petition against petitioners 2 to 4, accused number 2 to 4 for the offence punishable under section 417, 420, 506, 494, 498A, read with 34 of IPC is allowed. And the petition filed by petition number 2 to 4, accused number 2 to 4 for the offence also allowed. Quashed. Yes.
Serial number 8.
Authority portion ಸರಿಯಾಗಿ ಮಾಡಬೇಕು.
Serial number 8, Sharath Jain.
I represent the
Take notice, my
petitioner.
lords. Notice has to be ordered.
It's a successive bail
Additionally,
petition.
it takes notice for respondent. You will take notice next date.
Please.
Yes.
Serial number 10.
This time.
Chandrana Tariga K. Further arguments?
Lordship, kindly pass it. Kindly pass over.
Why? How many times it is to be passed over? Yes, what do you say?
As per 199 of CRPC, magistrates have no power to send the for investigation under section 156(3), my lordship.
Then,
So in
what
this-
about the other offences?
Even if the other offences are also included.
Why? Is there any bar for referring for investigation for other offences?
Listen, ask.
Charge sheet was not filed for the offence of defamation.
Please, my lordship.
That was for 171 G
G
and 504.
and,
There is no bar for investigation by the police.
After the magistrate order, the police filed an FIR, then filed charge sheet.
Maybe. FIR for which, what offense?
534, 120B, 171G, 503,
FIR under section?
499.
FIR under for the offense?
500.
500.
34, 504, 120B, 171G, 503, 499, and section 67 of Information Technology Act.
Yes, now charge sheet is already filed.
Please, my lordship.
They have not filed charge sheet for other offense except 171G, 504.
Please, my lordship.
Now what is your contention? Why it is to be quashed?
And my lordship, kindly see the Mahajar. In the Mahajaರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಏನು the allegations about in the
No, where is
private
the charge
complaint
sheet?
is that
Where is the charge sheet? What is the?
my lordship,
Page number 26.
starts from page number 26.
30, come to page number 30.
Please, my lordship.
Section 171G is fairly made out.
And my lordship, this petitioner was not contested for that election, my lordship. They are both are from the same party. This is the allegation. The previously, my lordship, in the year 2020, she filed complaint against this respondent number 2. In the year 2020, on 21/3/2020, this petitioner filed complaint against the respondent number 2. Again, in the women police station. And that effect, my lordship, we filed a counter complaint.
So counterblast.
Please, my lordship.
You file another complaint. Petitioner has not contested the election.
No, my lord, she has not contested. They both are from the same party.
Respondent contested.
Respondent to contest.
That is why 171G.
Yes.
Please, my lord. Yes.
If you publish such as what is that statement pertaining to her, relating to her, his character, definitely it will have a bearing on the result. There are prima facie materials to constitute 171G.
But
For defamation, no charge sheet is filed.
And what's in the Mahajar itself, it says that there is no such a message from this odds of.
Then why charge sheet is filed? What is the basis? No, there was no message because you deleted it.
Yes.
Offense is already committed.
211 ಅಲ್ಲೂ ಹಾಕ್ಬೇಕಿತ್ತು. ಕ್ಲೀನಿಂಗ್ offense ಅಂತೇಳಿ ಅದರಲ್ಲೂ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅಂತ.
Yes. Why not for ಏನಿದೆ? Intentional insult. That also arises. When you make personal allegations regarding character, why not for will also be invoked.
The coordinate bench of this honorable court passed on judgment as even if the other sections include also section 199 of CRPC applies.
How that will help you, madam? 199 of?
199 of CRPC left.
The bar under bar to
199.
199. 499 offences cannot be, my lords, filed directly before the police.
Yes.
Here is a case where, my lords, we have filed a private complaint. The learned magistrate, my lords, referred the matter.
See, FIR was also registered for the said offense of defamation, right?
Yes.
After that,
but now we are at the stage when the charge sheet is filed. At the most, charge sheet to defamation ಇದ್ದಿದ್ರೆ ಅದನ್ನ
ನನಗೆ ಕೇಸೇ ಇಲ್ಲ.
Procedures lacks, my lord. 156 3 there is no power to.
What about you restrict your argument 171G and 504? Now only those offences are made out.
That is only after investigating they filed charge sheet. The under defamation matter, my lord, police have no authority to investigate.
If the charge sheet is filed for the offense 499 500, you are right. But they have not filed the charge sheet for the said offense. Baral dismissed. The sole accused.
Yes. Accused,
the petitioner being the accused. In CC 987 of 2021, pending on the file of the learned principal civil judge in JMFC Puttur, DK, for the offense under sections 171G and 504 of IPC, is seeking to quash the criminal proceedings initiated against him. Order so and so negative for the following reasons. Respondent number 2 has filed the private complaint before the trial court in the PCR number. ಎಷ್ಟು PCR number? ಎಲ್ಲದು dash dash unnumbered. Okay.
Unnumbered PCR.
Subsequently, it must be numbered. Unnumbered PC register refer ಆಗಲ್ಲ ಪೊಲೀಸಿಗೆ.
ಮೆಮೊದಲ್ಲಿ ಕೂಡ ನಂಬರ್ ಇಲ್ಲ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಗೆ ರೆಫರ್ ಮಾಡಿದ ಮೆಮೊದಲ್ಲಿ ಸಹ ನಂಬರ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಪೇಜ್ ನಂಬರ್ 22 annexure B. For other offences, my lordship, yesterday. Yesterday.
3 of 2021.
Page 26 at the chart. Varadi number 3 of 2000.
Crime number ಎಷ್ಟು?
Crime number
5 of 2021.
Of which police station? ಪುತ್ತೂರು ಅಲ್ಲ.
Dakshina Kannada Crime Post.
CN police station.
My lordship, one submission. Yesterday I referred one citations. In that citations for other offences, that is not for defamation. Other offences, first they have to approach under section 154(1) to the jurisdictional police station. Idalli jurisdictional police station alli approach ಆಗ್ಲಿಲ್ಲ.
But at that time defamation
that need to be
499
endorsed in this private complaint.
At that time, as per the private complaint, 499 and 500 was the offense. There was a bar for filing complaint, first information. ಆಯ್ತು ತಗೊಳ್ಳಿ, ಏನಾಯ್ತು? CR 3 of 2021 alleging commission of the offense punishable under sections 500, 504, 120B, 171G, 503, 499, read with 34 of IPC, and under section 67 of IT Act. The trial court referred the matter for investigation under section 156(3) of CRPC. After investigation, the final report came to be filed for the offense punishable under section 171G and 504 of IPC. The petitioner, being the accused, is seeking to quash the criminal proceedings initiated against him, now pending in CC number so and so. Next. Learned counsel for the petitioner contended that the respondent had not filed the first information under section 154 of CRC with the police, but directly approached the learned magistrate by filing the private complaint, which is bad under law, and there is violation of the directions issued by the apex court in Priyanka Srivatsav's case. But the fact remains that respondent had invoked section 500 and 499 of CRPC of IPC, and under such circumstances, no first information could be filed with the police. Section 199 of CRPC is a bar for filing the information with the police, and it is only a private complaint which is to be filed. Therefore, I do not find any merits in the contention taken by the learned counsel for the petitioner. Next. The second contention raised by the learned counsel for the petitioner is that when the offense under section 500, 499 and 500 is alleged, the learned magistrate could not have referred the matter for investigation under section 156(3) of CRPC. Even though the learned magistrate has referred the entire complaint for investigation, comma, it is to be noticed that the respondent has alleged commission of offence punishable under section 504, 120B, 171G, 503, read with section 34 of IPC and under section 64 of IT Act. The police was required to conduct investigation, and accordingly it is referred for investigation, even though the learned magistrate could not have referred the complaint for the offence under section 499 and 500 to the police. There was non-application of mind by the learned magistrate to that extent. However, the fact remains that after investigation, the final report came to be filed only for the offences under section 171G and 504 of IPC. No, there is no final report regarding the offence under section 499 and 500 of IPC. And under such circumstances, I do not find any reason to quash the criminal proceedings on the said ground. Next para. The final report filed by the investigating officer discloses prima facie materials to constitute the offence under section 171G of IPC. Admittedly, respondent had contested for the election, and at that time objectionable statement relating to the personal character and conduct of his personal character and conduct was said to have been published and circulated in through WhatsApp. Through WhatsApp in a group. Of course, it is stated that the said chat message was subsequently deleted, but there are prima facie materials to constitute such an offence under section 171G of IPC. Next. The other offence alleged against the petitioner is under section 504 of IPC, which refers to intentional insult with an intent to provoke breach of peace. When it is the specific contention of the complainant initially and now the contention of the prosecution that objectionable messages were circulated in the group relating to the character and conduct of the respondent who was the candidate contested for an election, definitely section 504 of IPC could be invoked. In view of the above, I find prima facie materials to constitute the offence under section 171G and 504 of IPC, and therefore I do not find any reason to quash the criminal proceedings. Accordingly, I answer the above point in the negative and proceed to first appeal. Petition is dismissed. ಯಾವುದು ಏನು ಸಭೆ ನಾಳೆ ದಟ್ ಯಾರಿಗೆ ಅವರಿದ್ದಾರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 19 tomorrow.
ಇದು ಮೆಮೋ ಆಫ್ ದಿ ಇದು ಡೆತ್ ನೋಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟಲ್ಲಿ ರೆಕಾರ್ಡ್ ಹಾಕ್ಬೇಕಲ್ಲ. ಮೇಡಮ್ ಸೌಮ್ಯ ಅವರೇ, ಇದು ಮೆಮೋ ಆಫ್ ಡೆತ್ ನೋಟ್ ಕೊಟ್ರಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಅಲ್ಲಿ, ಇದು ರೆಕಾರ್ಡ್ ಆಗ್ಲಿಲ್ಲ. ನಾಳೆ ಕೊಡ್ತೀರಾ ಇದು? ತೊಂದ್ರೆ ಇಲ್ಲ, ಕರೆಕ್ಟ್ ಸರಿ ಸರ್, ರೆಕಾರ್ಡ್ ಆಗ್ಲಿಲ್ಲ, ಇದು ಪೆಂಡಿಂಗ್ ಕೊಡ್ತಾರೆ. ಅದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಜಸ್ಟ್ ಡೇಟ್ ಮಾತ್ರ ಬರೆಯೋದು ನಾನು. ಅದಕ್ಕೆ ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಓಕೆ ಓಕೆ. ಅಲ್ಲ ನಾನು ಇವ್ರನ್ನ ಮೇಡಮ್ ಅವ್ರನ್ನ ಸೌಮ್ಯ ಅವ್ರನ್ನ ಇವ್ರನ್ನ ಇವತ್ತೇ ನೋಡ್ತಾ ಇರೋದು ನಾನು. ನೋಡಿದ್ದೀನಿ ನಾನು ಆರ್ ನಟರಾಜ್ ಸಾಹೇಬ್ರು. ಒಂದಕ್ಕೆಲ್ಲ ಬಂದ್ರೆ ಗೊತ್ತಿರಲ್ಲ ನಮ್ಗೆ. ನಮ್ಗೂ ವರ್ಡ್ 482 ಇತ್ತಲ್ಲ ಮೇಡಮ್, ಬರ್ತಿದ್ರಿ ನೀವು. ಅಲ್ಲ ಅಡಿಷನಲ್ SVP ನೀವು. ಅಂದ್ರಿಂದ ಹೌದಾ? ಹಾ ಓಕೆ. ಅದು ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ನಿಮ್ಗೆ 3ಗೆ ಅಲ್ಲ 3ಗೆ ಸೌಮ್ಯ ಅವ್ರನ್ನ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀನಲ್ಲ ಸರ್. ಇಲ್ಲೇ ಇದೆ ಬಿಡಿ ಅದು. ಆಮೇಲೆ 6ಗೆ ನಿಮ್ಗೆ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ. 10ಗೂ ರಂಗಸ್ವಾಮಿ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ. ತೋರಿಸಿ. 3 ಇಲ್ಲೇ ಇದೆ. ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ. ಅದು ಚೆಕ್ ಮಾಡ್ಬೇಕು, ಅದಕ್ಕೆ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡಿಲ್ಲ ನಾನು ಹೋಗಿರೋದು. ರೀಕಾಲ್ ಆಗ್ಬೇಕಲ್ಲ ಇದು, ಮತ್ತೆ ಇಲ್ಲಿ ರೀಕಾಲ್ ಮಾಡೇ ಇಲ್ಲ. ಯಾರು ಮಾಡ್ಬೇಕದ್? ನಾನ್ ಮಾಡಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನೋಡಿ ಚೆಕ್ ಮಾಡೋಣ ಅಂತ ಇಟ್ಕೊಂಡಿಲ್ಲ. ಮಾಡ್ತೀನಿ ಬಿಡಿ. ಸೌಮ್ಯ 6 ಇರೋದನ್ನ 6 ರಂಗಸ್ವಾಮಿ. ಆಯ್ತು ಸರ್. ಆಯ್ತು ಸರ್. ನಾಳೆ ಹಾಕಿ ಅಂದ್ರಲ್ಲ, ರಿಪೀಟ್ ಅದು. ನಂಬರ್ ಕೊಟ್ಬಿಡೋಣ. ಇದೆ ಒಂದೇ ಅಲ್ಲ? ಒಂದೇ ಮುಚ್ಚಿದ್ದೀನಿ, ಬರಿಬೇಕು ಅಂತ. ಇಲ್ಲೇ ಬರ್ಕೊತೀರಾ? ನಂಬರ್ 19 ಅಲ್ಲ? 19. ಇದು ಊಟ ಮಾಡ್ಕೊಂಬಂದು ನೋಡ್ತೀನಿ ಸರ್. ಇದಿಲ್ಲೇ ಇರಲ್ಲ ಇದು? ಇದೊಂದಿಲ್ಲೇ ಇರಲ್ಲ? ಅದೊಂದಿಲ್ಲೇ ಇರಲಿ. ಇದೆಲ್ಲ ಹೋಗ್ತೇವೆ. ಇಲ್ಲಿದೆ. ಅದೊಂದು ರಿಪೀಟ್ ಕಳಿಸಿರ್ತೀನಿ ಬೋರ್ಡ್ಗೆ. ಯಾರು ಲಿಸ್ಟ್ ಮಾಡೋದು? ಮಂಜು ಮತ್ತು ಕ್ರಿಕೆಟ್ ಮಂಜು. ಸರ್ ಓ ಬನ್ನಿ ಮೇಡಮ್, ನೋಡಿ ನೋಡಿ ಹೆಂಗೆ ಹೊರಟೋಗ್ತಿರಲ್ಲ. ಬನ್ನಿ ಬನ್ನಿ, ಹಲೋ ಬನ್ನಿ. ನಾನು ಊಟಕ್ಕೆ ಹೋಗ್ಬೇಕಲ್ವಾ? ನೋಡ್ಬಿಟ್ಟು ಹೆಂಗೆ ಹೋಗ್ತಾ ಇದೀರಿ? ಯಾರ್ ಬೇಕಾಗಿದ್ದು? ಗೀತಾ 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 ಇಲ್ಲ ರೀ, ನನಗೆ ಫ್ರೈಡೇನೆ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ಗೀತಾ ರಜಾ. ಹಾ, ನಿಮ್ಗೆ ಹೇಳಿಲ್ವಾ? ಸೊ ಬ್ಯಾಡ್, ಸೊ ಬ್ಯಾಡ್. ಹತ್ತು ನನ್ ನೋಡು, ನಿಮ್ ಫ್ರೆಂಡ್ ರಜಾ ಹೋದಾಗ ನೀವ್ ಬಂದ್ ಮಾಡ್ಬೇಕು ತಾನೆ ನೀವು ಕೋರ್ಟಲ್ಲಿ. ನಾನ್ ಮಾಡಲ್ಲ ಅಂತೆ ಹೋಯ್ತಾ ಇದ್ದೀರಾ, ನಾನು ಕರಿತಾ ಇದ್ರು. ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ ನೋಡಿದ್ರು. ಹಾ ಅಯ್ಯೋ ದೇವ್ರೆ, ಯಾಕೆ ಮೇಡಮ್?